started. Thank you all for being here. I appreciate the time and attention everyone takes. We have minutes from the July 10th and August 21st meetings. Are there any changes or corrections? I have already heard one. Senator McGinn was listed as absent, but she was online. And that was, which one was that? The August 21st meeting. Are there any other changes or corrections? Oh, sorry, Jordan, I should have waited for you to get back here. All right, then can I get a motion to approve the minutes as corrected? Representative Carmichael.
Thank you, Madam Chair. I move that we approve the minutes of the August
21st and July
21st and July 10 meeting with the notation or the change that we believe that Senator McGinn was present at the August meeting.
Okay. Do I have a second? There's a second by Representative Penn. All those in favor? Aye. Opposed? Same sign. Minutes are approved. Can we just make note of who's on WebEx, please?
Madam Chair, did you want us to speak up? This is Senator Warren.
We were just about to ask you to speak up. So Senator Warren is online.
Also,
Yes,
Representative Sawyer.
Representative Sawyer. And we'll just go around and tell who is here. Maybe that will keep that problems from happening. So we'll start with the senator at the end. Just tell us.
Thank you. Good morning, Madam Chairman. Senator Tyson, Senate 12th District. Thank you.
Also, good morning, Senator Marcy Francisco, Senate District 2.
Pleased to be here. Thank you, Madam Chair. Patrick Penn, Representative House 85.
I'm Representative John Carmichael from the 92nd District, and I might also indicate that I'm sure some of our other members will be here shortly. In fact, there's Representative Wagner now, so just because we don't say hello initially this morning doesn't mean that these members won't be in attendance. They're just delayed.
We'll just add them as they come in.
I saw a barricade in front of the State House. I'm sure that delayed their progress.
Representative, would you like to introduce yourself?
Yes, Representative Paul Wagner from Hutchinson. Good to be here.
And Barb Wasinger from 111th District, Representative. Senator Warren, what is your district?
Yes, District 11, and I am on my way in, delayed slightly, but we'll be there soon.
Okay, great. And Representative Sawyer.
Yes, I'm here. Representative Sawyer,
right.
I'm here online.
Okay,
95th
great.
District, Wichita.
Thank you. All right, let's do a review of questions asked on 2022 HB 2087 forms. That'd be great.
Good morning, committee.
Good morning. Thanks for being here, even though you have to.
House Bill 2022, House Bill 2087. Y'all approved the questions to be, oh, sorry.
Introduce yourself.
Oh, I'm sorry. Jill Shelley, Legislative Research Department. Thank you. Sorry. Okay. House Bill 2022, House Bill 2087 required the agencies to review each of their rules and regulations and evaluate them as to whether they're necessary for the implementation and administration of state law, or they can be revoked. To help answer those questions and to be able to provide the answers to you in a somewhat comprehensible manner that's comparable across the agencies. We developed a spreadsheet. This committee approved the questions for that spreadsheet at its December meeting. I've provided a list of those questions for you today as a reminder as to what those are. My question to you today is whether those questions need amendment or change or changed in any way. The 2024 agencies are anxious to get going on this review. We provide a spreadsheet to them with the questions, and we want this to be as useful to you as we can make it. So they've started contacting me in June. So we're kind of anxious to get those going for them. So I would like discussion with the committee or approval to go ahead with the questions as they exist in their current form, or that's the pleasure of the committee.
Okay, well, let's open this to see if anyone has any discussion about the questions. And we welcome Senator McGinn as she is with us in the meeting because we kind of talked about it, who all is here. That's this sheet of paper, in case you haven't already looked at it. Are there any questions or comments? Senator Tyson.
Thank you, Madam Chairman. Thank you, Jill. This format is wonderful. The effective date, is that the date that it was supposed to be effective, that the rule and regulation was to go into place by statute, or what effective date is that?
The effective date of the rule and regulation itself.
That it actually went in?
Yes.
Okay, so is there anywhere on the sheet that we would see the date of when it was supposed to be implemented? It would be nice to have that. We've had a few that should have been implemented years ago and haven't been.
Yes, and we keep a list of those in the back of the Rules and Regulations annual report for at least the previous 5 years. As requested by this committee, we also provided on the website where the agency responses are provided, the list of the authorizing and implementing statutes. And those have dates attached, I believe. Yeah, the date the last amendment to that statute happened is part of that spreadsheet.
Does that answer your question, Senator?
It does answer the question. It doesn't, I'm not sure where is this part of the sheet that'll be posted, or how will the sheet be used?
Yes, the responses to the questions are all provided on the KLRD website for this committee. It's committees, JCAR, and then there's a little tab that says House Bill 2087 reports. The summaries are there, and the response from each agency is also posted on that website.
Okay, I just want to make sure, Madam Chairman, that the data with the implementation and what expectations were put in legislation are also part of it. So this isn't a complete list, is what you're saying?
These are just the questions.
Right. These are the questions that they answer, and then
if you go on the reports, they have spreadsheets.
okay, we don't have that spreadsheet. So okay. Thank you, Madam Chairman.
You can pull it up.
We actually did bring copies of the summary spreadsheet. We could distribute those if you'd like.
That would be helpful. Yes. Thank you.
Dismiss his abilities. Yes, that's what we gave you a different one. And then there's also Representative Wagner.
if I may, explain the two spreadsheets.
Didn't you give it to me? Yeah. Okay. Okay. Also, Representative Wagner has a question.
Yes, thank you, Madam Chairman. This is very helpful, this color-coded guide. I guess my question is on the green part where it says ties to federal programs. There's two questions that don't have a yes or no. Are they not required, or we could require them but we haven't, or what's? I mean, they both frankly seem like very good questions to ask. And what is the status of those two?
They were provided as short answers in the responses from the agencies. And I needed to, I am not aware of all the federal programs that through which the state of Kansas gets money, and I didn't want to offer a list.
If I may, Madam Chairman. So the question, if the rule or regulation is federally required, the state and federal program names and the federal agency name, that is something they're supposed to answer. It's just there's not a limit on, or they don't have to answer that.
They would answer that only if there is, if the rule and regulation is federally required.
Okay. And likewise, but if it is federally required, they are supposed to answer that, and also the amount of federal money. The other question could be in jeopardy, the approximate amount received. That is something that they are also supposed to respond to per this House bill. Okay.
Well,
just want to clarify.
That is not specified directly in the bill, but it was part of the questions that were approved by this committee to be answered by each of the agencies. That question was based on questions frequently asked in this committee.
Okay.
These are all the questions that we came up with.
Right.
We just want to make sure that there isn't something that someone sees that we're missing. Representative Penn.
Thank you, Madam Chair. Madam Chair, my question is kind of, I hope it's not too complex, and it may already be in the potential for revocation section right there. What I want to get after is if there's a rule or regulation change, how does it impact other regulations? So would the agency come up on the net and either capture which rules, regulations are being, exactly which ones are being impacted, which ones are being pushed out or added to. I think the questions that are asked right here, the last two questions in that blue section kind of go to that. And Madam Michelle, if you could speak to that, maybe that's where it's located. But otherwise, is there a way for us to see what regulations are being added to or being completely pushed out with the advent of a new regulation? Does this capture that information?
It would capture it as a relatively recent revocation, but this does not attempt to capture each amendment to a rule and regulation.
So it doesn't show the second and third order effects, if you will?
No.
Okay.
Senator Francisco.
Thank you, Madam Chair. Thank you, Jill, for bringing this. So the question I had just when I read through this was about in the potential for revocation. The second one just says, is the rule and regulation being revoked? And I don't know that that's potential for regulation. And it might be a good question to answer both before we talk about necessity and talking about revocation, because it sort of sets the stage for if you say it's not being revoked, then you would look to the necessity. And if you say it is being revoked, then describe how it would affect Kansas. I don't know if that makes any sense to you, but in some ways that seems a better question to just have at the beginning of the set of questions.
So may I make sure I understood? So move that question, is the rule and regulation to be revoked or being revoked? move that ahead of the yellow section or at the top of the blue section?
I think ahead of the yellow section, because if you say no, it's not being revoked, then it's really important to answer the yellow section. But it just seems that that sets a stage. But I'm not the one that's going to have to interpret all the information, so I leave that.
That's a fair question. Anyone on WebEx have a question? Well, I'm looking at this and I think, I don't know how. I think you've done an excellent job. And other than rearranging some questions, until we get into the weeds with this as we go along, we may see more issues as we go along and may have to go back and adjust the questions then. But I'm not seeing a lot of problems with what questions we have so far, other than that rearranging. And I don't have a problem with that. Does anyone else? Senator Francisco.
No, I agree that this is sort of a great outline. I'm reading back through necessity, and I'm wondering if we're saying, does the rule and regulation serve an identifiable public purpose? Would we want that purpose to be identified rather than simply yes or no? Because if they answer this, it's going to just say, yes, it's necessary to serve an identifiable public purpose, but we won't know what the agency thinks that public purpose is.
Is there someplace else that explains that in our questions or their answers? Do you know?
Yes, I believe that the answers to briefly describe how revocation would affect Kansans does get to that. The questions that are in the necessity section come almost word for word from the law as it was passed.
Does that?
I appreciate that, and I think we will see that in revocation, but it may be then important to say describe how retention would affect Kansans and also revocation. We're only looking at one side of that question, but should have looked at the bill more carefully.
If I may, Madam Chair.
Yes, please.
On this summary version, you will see some of the answers to that question in the first column. Some of the agencies provided a discrete answer for each of their rules and regulations. Some went with a short-ish list of standards that they could use, answers they could use for multiples. And I think some of the answers kind of get to your question, but of course we can rearrange, reword, however the committee pleases.
Thank you, Madam Chair. Jordan Milholland, Legislative Research. Just letting the chair know, based on Senator Tyson's question from earlier about the yet to be promulgated rules and regulations, I went ahead and made an excerpt out of our report of that table. And so I emailed that to committee members, and we're running copies, and Luke is grabbing some paper copies of that as well. It's to be handed out.
All right. Thank you very much. Representative Penn.
Thank you, Madam Chair. And I don't want to belabor the point, but I understand the good senator's question here. And I think this is amazing as far as the framework goes. And I think you guys have done an extraordinary job, because to just create a dashboard that is easily identifiable with data entry and understanding of what it is that's being placed in there is great. I think on the necessity piece right there, if we're talking about revocation or retention, we need to allow that space in there as well. And maybe with the question on the yellow section, is it necessary? Yes or no? If yes, comment and create a comment section there as well. Or if it's necessary for retention versus being ruled out. I think that those would a section right there that would allow the agency to put that context there would go a long way, both for the public and for the committee. And as I was asking in my earlier question, Madam Chair, if the agency can actually shed some light as if they're going to try to promulgate a rule or a regulation and they deem it necessary for implementation, we would like to have some fidelity on what other rules, regulations, or statutes are going to be affected with just a snapshot. And I think that's something that they can come up with if they've already conducted the research and tried to promulgate said rule or regulation. They can shed that light for us in another comment section as well. Because I'm a big fan of getting rid of regulation. So I would love to see what regulations could actually be affected. And perhaps if they're redundant, how do we address that as well? Thank you, Madam Chair.
If I may.
All right. Yes,
A
please.
few of the agencies did identify rules and regulations that were redundant with other rules and regulations and also with statute. I believe some of those are proposed for revocation today, actually.
Okay. All right. And I think Representative Penn just wants our spreadsheet to get longer, and longer. So then we need 3 screens on our desks to be able to see everything.
As
I think this is great. And
as I discussed, to print out the answers that we got this year would be 400 ledger size pieces of paper front to back. And next year's list is longer. So just that's why it's online instead of on a pile in front of you.
are there any other questions or comments? Here comes poor Luke running upstairs. Thank you. Here. And then we've got one over there. All right. Are there any other questions or comments? Thank you so much. You put a lot of time and effort in this. And I appreciate all the work that you've done and all of KLRD and the advisor's office that had to be a part of this. I'm sure it was not a fun job, but
We received a lot of assistance from the Secretary of State's office too. I
good. Yay.
acknowledge.
All right, Secretary of State, thank you all for everything that you've done. So I think you're off the hot seat now. Does anyone have any questions about this document that we just got? Before we move on. All right. Well, we're a little bit behind schedule, but we will go ahead and start with the Department of Revenue. It says that Taylor Murray, attorney, will be coming up, but it looks like Kathleen Smith.
That is correct, Madam Chair. Members of the committee, my name is Kathleen Smith with the Kansas Department of Revenue. Taylor is unable to be with you today, so I am stepping in. The Department of Revenue has 2 sets of regulations before you today. The first set is regarding a food sales tax refund program that has been repealed. During 2012, legislative session, House Bill 2117 provided that as of January 13, the food sales tax refund statutes found in 79-3633 and 79-3639 were to be repealed. And as a result, food sales tax refunds were no longer allowed. Legislation did come in right after that and put back in the credit, but it made it a non-refundable credit. So the refundable portion, the refundable credit is gone, the non-refundable credit is in. So we need to revoke the regulations that did speak to the refundable program. We've got 4 regulations, 92-19, 200 through 203, that we are proposing for revocation. The public hearing for these regs is scheduled for November 8th at 9 o'clock. And the notice was published in the Register September 7th of 2023 and has also been published on our KDOR website. And if you would like, Madam Chair, I can walk through the revocations if you would like.
Does anyone, would anyone else like to go through those? Okay, no, I guess not. You may move on.
Okay.
Thank you.
Yes. The second set of regulations we have before you today, we are proposing the revocation of 31 regulations within the Division of Alcoholic Beverage Control. And I do have with me today Debbie Beavers, the Director of Alcoholic Beverage Control, and Audra Shugart, who is our Deputy Director. So they can answer questions specifically with any of these revocations. When we did our review, and this was the review based upon House Bill 2087, we found that some of these regulations were no longer necessary. We did submit the report to, submit the report as part of this House Bill 2087, June 1 of 2023. We reviewed 213 regulations for the division, and we found that 179 were necessary or still necessary for the implementation and administration of state law, and we found that 34 weren't necessary. Today we have 31 before you, 3 are still under review by council. Of these 31 regulations, 15 of them duplicate existing statute, and the rest do not reflect current industry practices or are inconsistent with statute. So there's around 16 of those. As part of the streamlined process due to House Bill 2087, we submitted the notice of revocation of these regulations to the Attorney General on August 14th of 2023 and received approval from the AG on August 18th of 2023. We submitted the notice of revocation to the Joint Committee on Administrative Rules and Regulations on September 11th of 2023. And we did publish the notice of the right to request a hearing regarding the proposed revocation of these regulations in the Kansas Register on September 14th of 2023, as well as publishing that on the department's website. And we are giving the public 30 days for which to request a hearing if they so choose. With that, Madam Chair, I can step through the revocations for the division of ABC if you would like.
Would anyone like us to do that? All right, Representative Carmichael.
Thank you. I think this may be the first regulation that the committee has seen under this new procedure that we adopted that basically allows the agency to repeal duplicative regulations or regulations which, for example, are based upon a statute that's been repealed. But could someone on the staff give me a quick refresher on how the procedure works under what I think was HB 2087? It's probably KSA 77440 and 77426, I guess is. But could someone just update us on how the process works? And I know we're going to see another one from the Secretary of State today and perhaps others.
Can you do that?
Well, I was thinking either the reviser or legislative research, but if neither of them can do it, I can try to do it, but I'm not sure it would be as helpful to the committee. The reason I ask is this is different than what we've typically been doing, and I think we're going to be doing a whole lot of these. And so I would hope that we can understand the distinctions in the procedure so we don't get confused. I get confused easily, Madam
We
Chair.
also have Laura Murphy who worked on it and
Yeah, wherever I just,
in the room. Yes.
Thank you, Madam Chair. Jenna Meyer, Advisor Statutes Office. And the section, the statutory section that comes into play here is KSA 77426, and it would be subsection D. And it's fairly self-explanatory, so I'll just kind of read it for you. Notwithstanding any other provision of the Rules and Regulations Filing Act, any regulation may be revoked pursuant to this subsection if that regulation is identified by the agency in the report submitted to this committee pursuant to KSA 77440 as one that may be revoked pursuant to this section. Goes on to say that a state agency may revoke the regulation by filing a notice with the Secretary of State and causing the notice to be published in the register. And such notice of revocation shall not contain any new regulations or amendments to that regulation. And prior to filing notice with the Secretary, the agency is required to hold a public hearing, submit the notice to the Attorney General for approval, and submit notice to this committee upon request of the chair and upon request of the chairperson appear before the committee. And after that notice in the register, the revocation would be effective 15 days following publication.
Yes, Representative.
so then one of my questions is, if the chairperson of this committee says, no, we don't need to hear about this, does this just go ahead and happen without anything other than just a notice to the public? And if there's no request for a hearing, no request for it to be presented to this committee, it just happens? I think that's the way this works. Well, could I get an answer, please, before the next question, Madam Chair?
So the revocation would have to be identified in the report that we receive from those agencies in the review that we plan to revoke this, and additionally would have to be approved by the Attorney General.
So this lady doesn't need to be here today on this second set of regulations, but for a request by the chair that it be presented to this committee?
That is correct.
And so the reason she's here is because the chair requested it, or did it just happen?
That's the question for the chair.
Well, I get notices from Jill that different revocations now are coming in.
Mhm.
And would you like to bring that before the committee? And I have said yes to everything
Okay.
that comes, because I don't want to make that decision
No.
for the rest of you. And I think, if we can say, okay, this all makes sense, you may sit down,
Yeah.
which we would really like us to say.
Well, I do appreciate the chair's policy in that regard, because I think it's a better one.
Yes.
Because otherwise, some of these things may never really get seen.
Well, I happen to know a few legislators, so if you ever wanted to tweak that, I think we could possibly do that.
Oh, I didn't vote for the bill in the first place. Thank you, Madam Chair.
All right, well then, Representative Penn.
Madam Chair, thank you. And you elucidated on it. And from what I heard, the staff read out is that it goes before both the Secretary of State for a hack on this. Is that correct? Secretary of State's office, as well as the Attorney General's office for approval. Is that what the statute reads?
Thank you, Madam Chair. The statute does not require approval by the Secretary of State's office, but it would require, I believe it says filing. Yeah.
So it's a review with the Sec State and a review with the AG or for approval, and a request from the chair to come before the committee. Those are the three that could potentially happen then, yeah?
So the Secretary of State would not be required to review it. It would just be filing. So you do a filing notice to the Secretary of State and then review by the AG.
And Madam Chair, if I may express thanks to to Kador for coming by with all of the review here for all of the statutes that are affected. This was my question for the earlier bunch, so thank you for being very thorough. I hope that every agency is just like you on this.
All right, Senator Francisco.
Thank you, Madam Chair. So my question was, and I didn't look it up, but in listening, I thought there was a requirement for a public, an open meeting, and could this meeting serve as that opportunity?
Thank you, Madam Chair. What the statute states is that upon the written request of a member of the public, hold a public hearing on the proposed notice of revocation. And I have not considered the other question if this meeting could suffice as a public hearing, although in the other statutes, during the public comment period, a separate public hearing is required, so that the statute typically, I'd say, contemplates the public hearing being separate from review by the Joint Committee on Administrative Rules and Regulations.
Representative Carmichael.
Thank you, Madam Chair. I'm pretty sure there would have to be something separate because public hearings are typically in front of the agency or its designee to gather information that I think would go back to the agency, whether it's the secretary or the board or whatever, because just a public hearing in front of us, as you know, we can't do much of anything. But that's just my guess. But my substantive question for everyone involved here is looking at the 14-5-1 series of revocations, which is the second packet. It does say here, these revocations will be effective 15 days after publication of this notice. Now, maybe I was confused. I thought the notice was published back in September.
What we published was a notice for the public to request a hearing if they so chose.
That was published in September.
September 14th of 2023, we're giving them 30 days. And at that point, then we will proceed with revocation if we do not receive a notice to request a hearing.
Well, I see in your introductory paragraph of the, like I say, the 14-5-1 et sec series of revocations, it says these revocations will be effective 15 days after publication of this notice. Is this the notice that you published on the 23rd? And if so, it would appear by what you've given us here that these were revoked effective Friday, maybe. Yeah, I don't know. I'm just trying to figure this out like everybody else. It's our first trip down this road.
Yes. Jill Shelley, Legislative Research. Yes, we are still trying to figure this out. And it is my understanding that the Department of Revenue voluntarily published that initial notice with the public. That notice in the register, I don't believe is required by the statute. They chose to do that.
So if I might ask of our staff, what publication triggers the 15 or the 30-day revocation? If that didn't trigger, if that wasn't the notice that triggers the count, what notice does trigger the 15 or 30-day or however many days it is? If somebody, I see Revisor Moyer may be of help to me, Madam Chair.
Thank you, Madam Chair. There is nothing in this statute specifying a 30-day notice relevant to revocation. That the steps that have to be completed are filing the notice of revocation with the secretary. But before that, the agency would have to hold a public hearing if requested, submit it and receive approval from the Attorney General, submit to this committee and come before the committee. And after those 3 steps are completed, they can submit the notice of revocation with the secretary. And following that, the revocation would be effective 15 days following the notice of revocation published in the register. So there's a notice of revocation sent to the Attorney General and then the notice of revocation published in the Kansas Register.
So is there an initial notification of some kind to the public or stakeholders about the intent to do the revocation, and that would trigger an opportunity for the public to request a hearing in front of presumably the agency or its designee, and then a second requirement for publication in the register following this meeting, which then triggers at least a 15-day window before the regulation goes into effect? I'm sorry, I'm just not following the process.
Thank you, Madam Chair. There's a little bit of ambiguity in the statute. It doesn't specify 2 separate notices being filed with the Secretary of State. The initial possible notice would be in that report after the review of the regulations pursuant to KSA 77-440. And the statute states that an agency may revoke by filing notice with the secretary and causing notice to be published in the register.
That sounds like a requirement for 2 notices to me. Is the revisor's interpretation that only 1 notice is necessary?
Before that, it does say 2 notices, being the notice to the Secretary of State and the notice filed in the Kansas Register. Yes. Whether there would be 2 notices required to the Secretary of State, I don't.
When is the
believe that
notice
says that.
in the Kansas Register filed in this process?
That would be filed after filing the notice of revocation with the secretary, and those 3 requirements have to be met.
So is it filed after this meeting?
Yes.
Okay. So how does the public know of their right to request a hearing in front of the agency on the proposed revocation? Is that just they're supposed to watch the filings? And I'm not being critical of you at all, but are they just supposed to watch the filings at the SOS to see if maybe something got filed? Or does it get published in the register, where most of us whose lives are so boring that we actually read some of these things, look for it?
There is no notice to the public required before. I mean, there's no like publication notice required on behalf of the agency.
So they have a right to demand or request a hearing in front of the agency, but they don't have a right to be told that there's going to be, or that the revocation is in process. There's nothing in the register that says, hey, if you don't like this idea, you need to request a hearing. The only way they would know is if they happened to be standing over at the Secretary of State's office when the filing was made.
I believe that, thank you, Madam Chair. I believe that is correct. Though that type of notice would be required for a standard revocation pursuant to the Rules and Regulations Filing Act. And this was meant to be more of, as my understanding, an expedited process that kind of doesn't require all of the hoops that a regular revocation would.
I just hope, Madam Chair, that in our haste to revoke regulations, that we don't deny the public an opportunity to be heard in front of the agency, because members of the public might disagree with the agency's interpretation that a regulation is duplicative or otherwise. Thank you for allowing me the time.
Absolutely. I think the general thought is revoking regulations is not as incendiary as putting new regulations on. So maybe there's some way it could be online so that people can find it. I mean, you can lead a horse to water, but you can't make him drink. I mean, you can. We can do as much as we can, and people will be like, I'm not reading that. I'm not going through the register for that. But I would think that the people who are concerned about different, alcoholic things would probably go look and see what was there, restaurants or clubs, or I think it's, and I know you can't answer this, but I thought it was interesting to see that you still had, this is your revoking KAR 14-19-31 about clubs. And very few of the people, the younger people here won't realize that you had to buy memberships to clubs in order to get a drink at a restaurant. And of course that got revoked in statute, but here it's still in here. So it's nice to see that that's gone. So anyway, thank you. I appreciate it. Are there any other questions for the Department of Revenue? You are off the hot seat.
Thank you.
We move on to the Kansas Bureau of Investigation. And that's Patrick. Welcome to committee, and please introduce yourself.
Thank you. Good morning, Madam Chair, members of the committee. My name is Patrick Porupski. I'm a laboratory operations manager at the Kansas Bureau of Investigation. I'm appearing before you today to discuss two sets of regulations that we plan to update. The first set is KAR 10-21-1, 21-3, 21-4, 21-5, and 21-6. These regulations pertain to the workings of the KBI DNA databank section. The DNA databank is responsible for the oversight of collection and maintenance and analysis of arrestee and offender DNA samples pursuant to Kansas law. This section also manages Kansas's contribution to the FBI's combined DNA database index system, CODIS, to link forensic samples to offender profiles. As background, KSA 21-2511 authorizes the collection of DNA samples from anyone upon arrest for a felony or one of 7 statutorily listed violent or sexually motivated misdemeanors. It also requires the KBI to promulgate rules and regulations for 4 things: the form and manner of the collection and maintenance of samples, a procedure which allows for defendants to petition to expunge and destroy sample profiles and records in the event of dismissal of charges, acquittal at trial, expungement, or an overturn of the verdict. Any other procedures for the operation of this section. And last, compliance with national quality assurance standards to ensure that the profile records satisfy standards of acceptance of such records into the National DNA Index System, which is the database that drives CODIS. Also, KSA 22-4907 authorizes the collection of DNA samples during the offender registration process if a DNA sample is not already collected in the Kansas system. The regulatory changes include updating FBI documents, KBI collection and expungement procedures, and making the regulations generally more clear and accurate. Thank you for your time today, and I'd be happy to answer any questions you have about the DNA databank regulations before continuing on to drug field tests.
Are there any questions? Representative Penn.
Thank you, Madam Chair. Thank you so much for coming today. Great name, by the way. Quick question. When you talk about the National DNA Index System and you have the ways that KBI can do well, you have to come up with a procedure for collection, is that talking about getting those particular DNA evidences out of the KBI system in the event of expungement, overturning? Is that what you were referring to just now?
So there's I think I have to answer your question in 2 separate ways. So part of these regulations dictate the way that those samples are collected at the time of arrest at booking stations. And then another portion of this is when those people are acquitted or the arrest was expunged, how they can petition to have those profiles and samples destroyed at the KBI.
And Madam Chair, if you allow me, the question that I have is, thank you for that, is what is that procedure with the national database as well? Do you all have a handoff, or do folks have a way to get that evidence destroyed as well? Is that something that you do organically, or do they have to petition for that to the national level as well?
No, that would just be what we would do electronically. The physical samples would only be at the KBI. That wouldn't go on to the national level. And then when the KBI would revoke those samples from our state system, they would get revoked from the national system.
Representative Carmichael.
Thank you. I want to make sure I understand this. As you point out, the actual samples are typically either in KBI lab's custody or the laboratory or agency that collected or analyzed the DNA sample. Is that right?
Yes, it's collected by the agency that books the arrestee and then is mailed to the KBI laboratory.
And so the federal government does not actually receive the biological sample,
No, sir.
typically.
Yes, sir.
Rather, they receive, and I don't know how you say it, but metrics, data that allows them to create an index so that when a search is done by agencies at the federal level through CODIS, they can be pointed back to the KBI lab has a sample that may match what you were looking for.
Point back to that the KBI laboratory has the personal identifiable information that goes along with that profile that got pushed up to the federal level.
And then when KBI is notified of either an expungement or an acquittal of a qualifying offense, if you will, for taking the sample in the first place, then KBI, with an exception we'll talk about in a minute, but KBI eliminates that information from its database.
Yes, sir.
And then it notifies the federal government, the CODIS system, I can't remember, every night or something like that, of what needs to be taken out of their database.
Yes, sir.
Okay. So an expungement is granted. KBI then takes it out of their database, notifies the feds takes it out of their database, and that's how those. And what happens to the actual biological sample itself?
It gets destroyed.
And it gets destroyed. The exception, of course, is if the individual has other qualifying offenses, if you will. They may have been charged more than once with a sex crime, and even though you're expunged on one, that doesn't mean you're expunged on all.
Correct.
And does anything about these regs really change the process that we've been using for the past several years?
No, sir.
These are not substantive changes. These look to me more like updates based on changes in what's in the Fed's manual and things of that nature.
Yes, sir. And a few updates that we needed to make after Kansas became an arrestee state.
Became a what?
An arrestee state, that the samples were collected at when someone was arrested rather than when they were prosecuted.
Thank you very much.
Right. I just want to make sure I have this right. I'll use the Honorable John Carmichael, Representative. If you take, he'd been charged with something and they'd taken his DNA and he wants it expunged, you would destroy the samples, but all that information has already been put in to the national database.
At that point, the information would have been put into the national database and it will be retrieved.
There's no problems with that? Because I know that, I mean, I'm just wondering when they go back and look at cold cases, if you're destroying all of that evidence and they discover, wow, that, you know, Representative Carmichael actually did this 10 years ago. Is that, I mean, I guess I watch a lot of crime shows, so I'm just wondering if that's going to cause a problem.
That's a good question. That's the way that it's dictated in the statute, is that the samples and the information would be destroyed if it was a expungible offense. If the offense was deemed to be expungible, whether through acquittal, expungement of the arrest, or overturn of the conviction.
So how often does something like this happen?
Do you mind if I refer to someone in the audience?
Yes.
Jeff Hahn is the DNA databanks supervisor. Jeff, how often do you have expungements?
Come to the podium, please, and introduce yourself. Thank you.
I'm Jeff Hahn. I'm the KBI DNA Databank supervisor. So you're asking how many expungement requests, or?
Yeah, what does that run yearly?
We get less than 10 we do less than 10 expungements per year, probably.
So it must be more stringent in order to be able to expunge things.
It's upon request by the individual, so it's not automatic. So it goes through a process.
But are there like 3 things that qualify you for expungement, like?
Acquittal. Yeah, acquittal, dismissal. Or overturn.
Okay.
Yeah.
All right. Representative Carmichael has a question for you. Sorry.
Quickly, and I don't know that's so much of a question. The policy decision that we made, right or wrong, was that if someone is arrested for an offense that requires a DNA sample and profile and keeping it at KBI and sending it to the feds, that if we later learn that this person didn't do it, they're not the offender, then we erase, if you will, delete, destroy those biological samples because in the interest of that person's privacy, cloaked with innocence, the presumption of innocence, the government shouldn't be holding their DNA profiles somewhere to use for who knows what purpose. The downside of that, of course, is if at some other day, some other circumstance, an unknown DNA profile pops up, if that hadn't been expunged, if it hadn't been taken out of the database, maybe it turned out that Representative Carmichael didn't do what he was charged with, but he did something else. And now, because the DNA sample or profile has been destroyed, you won't catch me because I'm no longer in the database. That, I think that's conceptually what we do. Is that right, gentlemen? Okay. I happen to think that's a good idea. I haven't done anything that I know of, but I just assumed that the government not have my DNA. My fingerprints are enough. Thank you.
All right. Senator Tyson.
Thank you, Madam Chairman. But there's no way for them to expunge from the national database, though. Is that correct?
To expand on that, so how it works is we delete it from our at the state level, CODIS, and it's all basically automatic. So if we delete a profile from the state level, it's automatically deleted and removed from the national index too.
Well, thank you, Madam Chairman. Just to be clear, it's deleted in the current database, but not in backup. So the data is still there. It still exists since we captured it in advance. I just have concern about somebody being innocent and going into the system when not needed. Thank you, Madam Chairman.
Representative Wagner.
Thank you, Madam Chairman. In part of the regulation, it talks about that the cost or fee associated with the collection of the DNA sample shall be paid by the person submitting the request. So that means you can apply for an expungement, but you have to pay for the cost of getting it expunged, or am I reading that wrong? I'm on.
That $200 fee is traditionally assessed by the court. So if there's a situation where it was being expunged, I can't imagine that fee would then be assigned.
Okay, I must be. But a follow-up question in a slightly different direction. Why, if a person is found innocent or not guilty, why is it not just an automatic expungement of the DNA material? Why do they have to apply to have the DNA removed from the database? I mean, is there some logic to that?
I believe that's the way that the statute was written, to apply for expungement.
So the statute could be changed to make it automatic rather than having to apply. I mean, is there some law enforcement objection to that?
I can't imagine on the spot the logistics that would be involved, but it's just the way that the statute reads.
Representative Carmichael.
Thank you. Just to help, in the Judiciary Committee, principally, we have had multiple bills that had to do with automatic expungements, and in the finding of, I think it's actual innocence, perhaps the wrongful identification, that does result in an automatic expungement of conviction. And I don't know whether that particular thing goes on to say if there are biological samples that they have to be expunged. But with respect to everything else, we've encountered a great deal of difficulty in figuring out the logistics of how to automatically expunge innocent people's arrests and even some mistaken convictions without that additional step. So I hope the representative can use a good creative mind and help us with that project, because seemingly we all think it's probably a good idea. We just haven't been able to figure out how to get through the logistics. So I appreciate your input, and thank you, Madam Chair.
All right. Senator Warren.
Thank you, Madam Chair. I'm looking at the regulation, and it references KSA 21-2511, and looking at 21-2511, it talks about collection of biological samples. And the statute 21-2511 mentions that the person's required to register as an offender pursuant to the Kansas Offender Registration Act any adult arrested or charged or juvenile placed in custody for the or charged with the following. And then we have this regulation. How is an arresting officer determining whether this particular arrestee is someone that they need to collect DNA from? And that's a policy decision, I understand, but since 21-25-11 is newly mentioned in the reg before us today, just wanted to know an answer to that if you could provide that.
As part of that statute, the agency that's booking this arrestee is supposed to look at their criminal history and see if they're already in the data bank. If they already are, then there's no further step they need to do based on their computerized criminal history. If it's not there and they satisfy one of these statutorily listed misdemeanors or being charged with any felony, then they would list that on the submission information coming to the KBI on what this defendant's actually being charged with. And if it's one of those qualifying offenses, it's supposed to be checked at the time of DNA collection. And it also gets checked at the laboratory before the sample is processed.
So it was your answer made it sound like DNA collection occurred as a process before the law enforcement agency was deciding what the law enforcement agency doesn't decide the charge, it makes the arrest, but I'm not certain that we're not going out there collecting DNA samples from every arrestee, correct?
No, only if they're arrested for a felony or one of those 7 listed misdemeanors.
And that's going to be determined by the arresting law enforcement officer.
Yes, ma'am.
And then the prosecutor will determine what the charge is.
That's my understanding. Yes,
and if the charge is different and doesn't fall within this statute that DNA was collected for, is there an expungement process at that point, or is it automatically deleted? Or tell me what happens in that circumstance.
I believe in that situation, they would also have to petition to have it removed because that arresting offense that they were initially arrested for, I guess that offense would be dropped. That's a really good question, though.
And then it would fall upon the arrestee to follow through and make sure that the expungement occurred.
Yes, ma'am.
Thank you for that answer. Thank you, Madam Chair.
Okay. Are there any other questions? I think you guys might be done. I have one question for Patrick Rubsky. You are a forensic chemist. Have you any relation to Perubsky's that in the recipe for those hot pickles? I think I have a child that really wants them. So
that was my grandparents. Yes, ma'am.
Okay, all right. So as a forensic chemist, is there just wondering because my kids really love them. So
yeah, they're delicious and I miss them.
But you can get more.
I might know somebody.
Oh, wow. With a forensic chemist, I think we could.
Is it the same problems as the chili or just the pickles?
Oh, both. Yes.
Oh. And the restaurant's reopened under somebody else now.
Yes, sir. They sold the facility, but they didn't sell the recipes. Yes, sir.
But the chili still stops probably in March.
I don't know. I don't know
either.
Yes.
I'm getting hungry. Thank you.
Yeah.
Are we assuming that then the recipes are available to buy?
I don't know.
All right. Thanks for being here. Sorry to pick. Oh, wait. Senator Tyson.
Thank you, Madam Chairman. A little bit of leeway, if I may. I have not being as versed in law enforcement. I have concerns as to when KBI comes into a case and doesn't come into a case and how that authority works. I think the legislature needs to look at that. There's murder cases or other cases going on and KBI doesn't come in and the locals may not have the experience needed. And KBI will not go into a case until they're asked by local law enforcement. Is that correct?
I do not know. I'm sorry. I only work in the laboratory division, and so I don't know the policy of the investigations.
Okay. Okay. I do know there's a case in Osage County that is involving quite a few issues. I wish, I don't know how to find that out, Madam Chairman. Who has the authority and when they are called into a case? Thank you.
The only thing I know from being a county commissioner is that it was usually the law enforcement agency that went ahead and asked them to step in. And if there's also, because particularly in smaller communities, everyone knows one another, and sometimes they pass things on for that reason as well.
But this is the opposite case. Local law enforcement is not asking them to come in, and so therefore they won't come in.
Is there, perhaps we could ask the KBI, is anyone, if an ordinary citizen thinks that there's something that's not right, would they consider going in by request of someone personally? Maybe we could send that to. Okay, great. Thank you. The revisor will do that. All right. Thanks so much.
I had one additional regulation
Yes.
to testify on, and that's on 10-22-1. As background for this regulation, 22-2902 allows for the court during a preliminary examination to admit into evidence an alleged controlled substance if certain requirements are made. One of those requirements is that the alleged controlled substance be subjected to a field test approved by the director of the KBI. KAR 10-22-1 is the regulation specifying those approved field tests. It currently contains reagent-based tests and instrument-based field tests. The KBI is proposing the additional of a third approved test type, immunoassay-based test. This additional section will contain one new KBI director-approved test, the Detectichem Incorporated Mobile Detect Fentanyl Test Strip Kit. The Mobile Detect Fentanyl Test Strips are lateral flow immunoassays, much like a home pregnancy test, that involves the officer swabbing an item of evidence, often merely the residue on the outside of the bag or the surface of a tablet, placing that swab into a buffer, and then adding the test strip to the buffer. After the development of the strip, it's read manually. The test line, one test line indicates a positive test for fentanyl or a fentanyl-related compound. Two test lines indicates a negative test for fentanyl or a fentanyl-related compound. Mobile Detect fentanyl test strips and the testing process were evaluated by the KBI laboratory. A robust validation examined the sensitivity, specificity, and efficacy and cross-reactivity of the fentanyl test strips was completed and to determine the viability of the strips as a field test for law enforcement. The results of this validation were documented in a formal report and provided to the KBI director for evaluation and approval. The use of this product is not a requirement. The addition of this product to the KAR provides law enforcement with an additional presumptive tool in their fight against the opioid epidemic. Thank you for your time today, and I'm happy to answer any questions about this regulation.
Senator Warren?
Thank you, Madam Chair. The legislature passed a bill this last session that decriminalized fentanyl test strips for the public. Are the test strips that you just testified about regarding this regulation, are those available to the public as well? Do you know?
I'm not sure if they have any purchasing guidelines, if it's law enforcement only or not. That's a good question. I don't know for sure.
Well, certainly by law, they're not considered in statute to be criminal tools. So I would think that we would be seeing these on store shelves, but that's not an answer that you have today. So
sorry.
But no, it's okay. It's probably not in your area. So thank you.
I want to apologize. I know the revisor wanted to say something earlier, and I completely skipped over you. Okay. I'm glad I didn't. Maybe I didn't. You just don't remember. All right. Are there any other questions or comments? If not, thank you so much for being here.
Thank you.
Both of you. I appreciate it. All right. Let's move on to the State Board of Examiners in Optometry. Looks like we have Jan Murray here. Maybe somebody else. Oh, they're all leaving.
Okay. Just me. I'm Jan Murray. I'm the executive officer of the Kansas Board of Optometry. And I have two regs that the board is just kind of more or less updating to the 21st century. And the first one is 65-4-4. And notice to the board, basically the only real change is that any change in contact information to receive notifications from the board, including the physical address, electronic email, and phone number. Before that wasn't in there at all. So like I said, last time it was updated was like 1993. So.
All right. Well, have you gone through all of your rules and regs yet?
The board is in the process of doing that. So you'll probably be seeing a lot of me.
Okay. Well, I appreciate your being here. Thank you. Does anyone have any questions? If not, you're up.
Then you on. Okay. The next one is 65-5-4, approved schools of colleges of optometry. Basically, they're changing it to the Accreditation Council of Optometric Education. If the school has been accredited by them, then the board will accept students from there. Before that, it was like the University of Missouri at St. Louis they existed on January 1st, 1991. So, which was way outdated.
Okay. Well, are there any other questions? I don't think any of us got travel vouchers, but we need to be paid for legislators being here. I'll be right back. I'll sign it. All right. Then thank you very much. I think
Thank you. That was easy.
We are letting you go without too much trouble. So, all right, we will move on now to the Emergency Medical Services Board, and it sounds like Joseph House is here. He's back. He's back.
Back, yeah, like a bad penny. Joe House, the Executive Director of the Emergency Medical Services Board. Yeah. Good morning.
Good morning. Thanks for being in committee.
Thank you. I'm here to present KR 10922, which is one of our operational regulations. Provides requirements related to applications, both initial and renewal for ambulance service permits, as well as ambulance licenses. And so what you've got before you is really a reworking to make it a little bit easier to read, although with the strike-throughs on there, it's not easy to read at all right now. But once we get those out, it'll be much easier to read as we go through. The big changes within it that we proposed are minimizing the repetition of submission of documents. And so typical renewal process, folks were required to go back through and resubmit things that they've already given to us, whether they've changed or not changed. And so within this regulation now, it's an affirmation on the renewal side that what we have within our repository is current and accurate. And so there were also, during the review, we noted a couple items that were specifically listed in statute over the years that were not amended into the regulation. So we did amend those within this regulation and added those. And that is all I have, unless you have any questions.
Does anyone have any questions for this gentleman? Representative Carmichael.
Thank you, Madam Chair. I take it all this collectively on this question's about, because my question is somewhere 10922 sub 14, and that's at page 3. Are you there?
Shortly.
Yep. This in part has to do with air ambulance or air transport. And, we're striking, for example, the regulation that the application include a copy of the standard airworthiness certificate of the aircraft. And I'm not after you about airworthiness certificates. The FAA is all over the operators about airworthiness certificates. But are we eliminating any review in the licensing process about the mechanical maintenance and so on of the aircraft? I'm looking 14 sub 2. There was inspection forms shall not contain any deficiencies. Are you getting out of the business? And I'm not critical. Are you getting out of the business of trying to determine whether or not a particular aircraft is safe or unsafe and leaving that to people who are experts in that? Help me with that concept.
Will do. Thank you for the question, Representative, no, we are not necessarily getting out of the business of verifying that it's being done. The fact that they provide us with their FAA registration number allows us to go out at any point in time and see their actual maintenance records in real time. And that's just leveraging what the FAA requires them to do in reporting to them. There's no need for them to report to us. We can actively go out into the FAA system and make sure that those aircraft are kept safe and maintained.
I'll try to get in touch with you sometime after the hearing and you explain to me how you do that based upon just the existence of an active registration number. Thank you.
All right. Well, I forgot to ask the Board of Optometry some of these questions, which now you're a fee-based organization, yes?
We do charge fees. We are actually funded from, we are a fee-funded agency as far as the state's concerned. We receive our fees from insurance premiums paid, not necessarily from our providers.
And how much money do you have in your unencumbered funds currently?
Very good question that I will get you an answer for.
Okay. I'm just curious to see do you know what all they do with these funds? Do they provide continuing education?
With our unencumbered funds?
Yeah.
We have no appropriation to spend those funds, so they just grow in a pot. It gets very inviting and disturbs us.
Any other questions? Thank you. If you could get some of that information, I'd like to see some of that.
Absolutely.
All right. Let's stay on task and we'll move on to Dan Riley from the Department of Wildlife and Parks. Welcome to committee. The last time you just had surgery. How are you?
Doing well, thank you.
Good.
Good morning, Madam Chair.
Good to see you.
Committee members. I am Dan Riley, Chief Counsel at Wildlife and Parks. And on the agenda today, we have 5 regulations, the first of which is KR 115-2-1, which is our fee regulation. And the proposal before you today includes a number of changes, the elimination of one category of fee, a decrease in another category of fee, and 7 increases in categories of non-resident fees. The elimination is of the disabled veteran license, which is a change that we're making pursuant to House Bill 2039 from last session, which paved the way to eliminate all fees charged to any disabled veteran with a disability assessed at over 30%. The provision in which we are decreasing the fees relate to the special hunt on their own land, which is being decreased from the current $85 to a $40 fee. And the categories in which we are increasing fees include non-resident hunting licenses, which we propose to increase from $95 to $125. Non-resident turkey permit application fees, which is a new fee that didn't currently exist. We propose that to be a $10 fee. Non-resident spring turkey permits, so one bird permit, we propose an increase from $60 to $75 for that fee. Non-resident combo 2 deer permit, currently that permit is $415, and we propose raising that to $450. Non-resident fishing license currently is a $50 fee, and we propose to raise that to $75. A non-resident or calendar day license for fishing is currently $7.50, and we propose to increase that fee to $10. And the last change we propose is the non-resident combo hunting and fishing license. Currently, that license is $135, and we propose changing that to $190. Are there any questions from the chair of the committee?
Representative Tyson, Senator Tyson, I apologize.
That's fine. I've served both. Thank you, Madam Chairman. Thank you.
Good morning, Senator.
Good morning. You knew I'd have questions.
Oh, I hope so.
Yeah. Yeah, and disappointingly so. One of the issues with non-residents in Kansas is that they apply for the permit, and if they are not drawn, they do not get their money back. Is that correct?
I believe so.
Yes, other states do return the money.
Some do, I believe. And I have an expert on wildlife issues from our agency with me today. Jake George, who's the director of our wildlife division, is here. So if the questions get over my depth of knowledge, and they probably will, I'll call Jake up and back me up in terms of the information. So
my concern, Madam Chairman, it's one thing if you were increasing the fees and these individuals were getting licenses and actually able to hunt in Kansas, but that's not the case. You're increasing the fee for them to even apply to come to Kansas with the possibility of hunting. Why?
Why? To increase revenue, actually, and to get us more in line with other states. Because I think that, and Jake can again speak to this better than I, but the increases that we propose do a lot to get us to the point where competing states that have similar opportunities for out of state hunters and fishermen are currently at in terms of the fees.
So would it take legislation for you to return the fees to hunters that do not receive a license? Or can you do that on your own?
I don't think it would take legislation to make that happen.
Go ahead and do.
Yeah, I haven't considered that issue, so I won't absolutely guarantee that, but I would think that could be a policy decision.
I would think that would be great, Madam Chairman, so that we would get more applicants and more possibility of hunters and increase your revenue by expanding out of state hunting. But if I may, Madam Chairman, absolutely. It's a little off topic and I guess I should wait, but you had told this committee that the Department of Wildlife and Parks was not going to do anything on deer baiting. And that is not the case. The actions of the department are completely opposite of that. So maybe, Madam Chairman, after we finish the rules and regs, I would like that addressed if we could.
I would like to inquire in terms of your question slightly. What actions are you specifically talking about? Because
I'm talking about the department going around the state educating people on deer baiting. If it's something that you're not going to take a position on or action on, then why are you going around the state and having educational meetings?
Because we have information that we think is going to be detrimental to the deer population if we don't make it known to the people that are out in the state and who would have the ability to do something in response to that information. What I said at the last meeting was that there's no plan for us to promulgate any regulations. There have not been. And having educational information sessions is not promulgation of regulations.
Well, constituents are upset, landowners are completely concerned about the actions of the department and feel like that you're posturing in order to take action. Thank you, Madam Chairman.
And I think we'd like a response from the secretary about that as well, if we could.
I'm sure he would be happy to, because from the beginning, the plan internally that we discussed was to collect the best information based on the science that was available and make that available to the people in a position to make a change and do the difference. And the amount of concern that generated was not anything that we intended. That situation in terms of the communication created a lot of concern that we never had any intention of, because our purpose was just to make the information known to as many people as we could, because we think the threat to the deer population is serious. So I'm sure the secretary would be more than happy to provide a response to the committee.
Okay. No, I'm glad that you lowered the special hunt on your own land fee. But I think it would be unconstitutional to tell someone they couldn't do what they wanted to. They can't even hunt on their own land.
Well,
without-
there are laws that apply to private property also. It's not do as you choose on your property just because you own it. But certainly there are restrictions on private property.
Well, disconcerting to me. I mean, I'm not a hunter. I do have constituents that feel like the wildlife and parks is basically getting inside of their property and telling them what they can do and can't do. So I think there's a fine line that the department needs to walk on so that you pay attention to the disagreements from landowners and hunters and try to work those out. Although I will say, the thing I keep hearing is that the Department of Wildlife and Parks doesn't want anyone to come in from out of state at all to hunt. And you're going to kill all of the hunting lodges and all the places that are getting money from people coming from out of state. That's another thing I'd like to have the secretary address directly. I've gotten emails, but I think it needs to be more public so that people hear him say, yeah, you're right. We don't really want people coming in from out of state. And I think that's a huge problem. If I hear it as often as I do and I know I'm in an area where a lot of people are hunters, but it's an issue and a real bone of contention.
Well, I'm sure that he would be willing to do that also, because that's a misconception that we need to clear up, because we appreciate out-of-state hunters. We gain a lot of revenue from out-of-state hunters, so they're a group that we certainly are not going to turn our back on or try to keep from coming in Kansas. But it is a fine line to balance, and between that balance and the balance of in-state hunters, because many times if the demand exceeds the availability of an area or an opportunity, then we have to make a decision between in-state or out-of-state hunters in terms of priorities. So that's another fine line that oftentimes comes into the consideration.
I appreciate your response. What I'm hearing from my constituents is that y'all are saying one thing. We're not trying to block these people. We're not trying to do this. But the actions speak louder than the words coming out of the mouth of the department. So you have a lot of work to do in order to try to make sure that these people understand. And I don't see your actions following what you're saying, not you in particular, your agency. Senator McGinn.
Thank you, Madam Chair. I'd just like to put a different perspective out there. Just like the water of the state of Kansas is not just contained within one county, it's contained with basins and the topography across the state. And the water belongs to the people of Kansas. We're talking about deer population, and I'm a landowner too, and we have land that is has been groomed for some hunting as well. And so to say that I ought to be able to do anything I want on my property, we're talking about deer population. And again, the deer are just like the water. They don't just stay on my farm. They don't just stay in Sedgwick County. They wander all across looking for water and looking for food. So to me, what we're trying to do is manage our deer population so that hunters will have something to hunt. And I think that's what they're trying to do. Be happy to hear from the secretary as well, but I just thought another perspective needs to be out there as well, coming from a landowner.
Thank you. Senator Warren.
Thank you, Madam Chair, and thank you for your presentation today. I have a couple of questions regarding your report, and the agency or the department estimates that the total annual costs are $3.74 million.
That's correct.
Did I miss in your statements why the increase of $3.74 million in fees, and that going to be used for?
The short answer is operating cost and to head off the inflation that's hit us on operating costs over the last number of years since the last time there were any fee increases. We haven't had any fee increases for a number of years. And the basic use for that additional revenue will be for that purpose, for operating and expense increases due to the inflation.
Is that officer salaries? Is that new vehicles? What is?
And Jake can answer this better than I. I think some of it would fall into the categories of equipment and vehicles and that sort of thing.
Part of your report says that there's no anticipated reduction in sales or demand anticipated with these fee increases. And you say that's because historically license and fee permit increases have not resulted in a reduction in the number of permits sold.
That's correct.
Could you expand upon that a little further about historically? What do you mean? When was the last time? And was it as big an increase as 3.74 million?
The historic perspective there relates back to the last couple instances when fees were raised in terms of the demand for licenses. And based on that history, the increases, one of which I believe was significantly larger than the fee increases we're talking about here, is a percentage, not necessarily as a total. But those fee increases did not result in a drop in the demand for licenses. And part of that history also includes our comparison to the cost that's charged by other states for similar categories of licenses. And again, those don't point to us pricing ourselves out of the market by the increases that we're proposing here. In fact, in most instances, I think we're probably still on the lower side of the states we would compare ourselves to. So
you haven't given any time frame of when the last time fee increases of any percentage were raised. Was it 5 years ago? Was it 10? What are we talking about?
I'm going to ask Jake to come up and answer those questions because he's the director of the wildlife program and he's got that information.
Thank you. And the concern is our business activities. We wouldn't want to negatively impact our business activities that are engaged in this industry. And it seems, 3.74 million is a lot more fees to be paid by persons engaging in hunting. And it's a little counterintuitive to say that the increase in cost in doing an activity won't impact the demand for that. So just wanted to explore that for a minute. And maybe the purpose is to negatively impact the demand. I don't know.
Certainly not. Thank you, Madam Chair, members of the committee. My name is Jake George. I'm the Wildlife Division Director. Was asked to come here today and serve kind of in my other role as the chair of our agency's revenue committee. So as far as the comparative process that we went through, I guess I'll back that up a little bit to answer your question first. 2016 was the last time that there were fee increases. And as an example, it was at that time a $25 increase in the non-resident hunting license. And we actually saw an increase in license sales after that point in time. And across the board, there were much further reaching increases in 2016 because the last time that they were increased prior to that was 2002. So quite a while in between there. A lot's happened. So as you guys are aware, the fee caps are set in statute. And the last time that those were changed was in 2002. So they haven't been increased. We're approaching 22, 23 years since those have been increased. The last time that we increased the fees in 2016 was the first time that we've done that since 2002. It was significant increases across the board. At that time, we reached the fee cap for resident fishing, hunting, and fur harvesting licenses. With the exception of those resident licenses, we are still below the cap for almost all of our permits and licenses.
So with that review, in comparing with other states, we looked at both resident permits as well as non-residents, and how we compared both nationally for licenses as well as regionally for comparable states for some of the permits. And where we set those with that 3.74 million, we feel it's pretty comparable. It doesn't put us at the highest end of that regionally, but above probably average, which with the resource that we have, we feel it's a good place to be.
Thank you for that historical look back. Appreciate it. So for areas of the state who don't necessarily have as much hunting activity as others, what Kansans can expect to benefit from the 3.74 million increase in fees is more officers, better equipment, as I think what I was hearing. Is that the intent of the department?
Certainly, we, for operational expenditures, would be looking at primarily infrastructure. With a lot of our state fishing lake dams in need of repairs, additional deferred maintenance on some of the properties. But certainly, we're trying to keep up with our ability to purchase vehicles, maintain vehicles, put gas in vehicles with the inflationary impacts that we've seen in the last 2 years.
So it's maintenance across the state as well. And I don't just mean to limit it to certain categories that are going to be used to be paid for by this, but you've hit on more of them.
And one of the additional opportunities, if we did have funds available for it, would be to increase some of the funds going back to private landowners in the state through our Habitat First, our private lands habitat program.
Thank you. Thank you for the additional information provided. Thank you, Madam Chair.
Representative Wagner.
Thank you, Madam Chairman. And kind of a follow-up on the question on the totality of the price increases. I was a bit taken aback that it was $3.7 million. Your total current income from permits is what, 10 million, 12 million? What is it currently a year?
It's between 30 to 32 million annually.
Okay, 32. Okay, so this is basically about a 15% overall average increase. Is that about right for your revenue? It's what you're expecting?
But with very specific permits, not an across-the-board increase.
Okay. All right, thank you.
Representative Carmichael, and then we'll get to Representative Penn.
Thank you, Madam Chair. I'd like you all to know that I was at Cheney Lake State Park last Friday evening. I found it to be perfect and wonderful in every way. It was clean, it was nice, wonderful campgrounds. I know you can't fill the lake up without rain, but for the $5 that I paid for that permit fee, I couldn't even take my wife and I to a drive-in. And I really appreciate the park and the work that you all do. And I hope you let the Secretary know that I, for one, very much appreciate it. Thank you.
All right, Representative Penn.
Thank you, Madam Chair. Can you all hear me okay?
Yes.
Okay, fantastic. I was listening to the testimony that was given to us by the proponent, and you said something about disabled vets. Could you explain what exactly is happening as it pertains to disabled vets? Are they receiving a fee increase?
Not at all, Representative. There was a bill that passed in the last session that eliminated all fees for disabled vets, and disabled is defined as any individual with a disability that's been assessed at 30% or greater. So basically what we're doing is striking out the fee line entirely for anyone that falls into that category.
Okay, thank you for that. And then the other question I have, when you're dealing with the vehicles, are you all under contract to switch your fleet of vehicles to EVs? Is that what the 3.7 million is for?
We're not currently. I think we're just beginning to explore some of those options, but a portion of the 3.7 million would be just to cover some of the increased costs that we've seen in the last couple of fiscal years with respect to vehicles and trying to maintain an operational fleet.
Okay, I would not be in favor of that, Madam Chair. And if you allow me one other question, when we're talking about comparatively speaking to surrounding states and counties or inside of our competitive states, I would imagine that we would want to make sure that this is a part of our portfolio as a state to attract business or business leaders or workers or whatever the case might be. So I'm not exactly understanding why we're increasing the fees to make ourselves less attractive across the board. I understand that there would be some, now that we're finally admitting that there's inflationary pressures, but I don't know if that's necessarily the right stance to have, that this is how we feel about it. I think there needs to be a little bit more granularity, a little bit more understanding of how we came to these price points. So if the secretary can give that to the committee, I would truly appreciate that, because we have to explain this as to why it is that these fees are going up this much. And I don't think that just kind of spitballing it and saying, hey, everybody else is doing it is sufficient. Thank you, Madam Chair.
And one thing that I'd like to point out that Senator McGinn also touched on, if we don't invest in the resource will not be there that people in other states will desire to come and partake in. So that's one of the reasons why a big part of Jake's headaches and day in and day out toils are making sure that we are doing that in terms of putting the investment back in the resource, so that Kansas is still a place that deer hunters want to come to, or waterfowl hunters want to come to, or fishermen want to come to. So that's a big reason for the requirements for the maintenance and the money going back into the program.
And sir, I don't deny you that point at all. All I'm saying is I'd like to see the numbers versus the emotion. I actually want to see what it is that we're proposing to increase these fees for, and how does it benefit Kansans versus, we're just doing it because everyone else is doing it. I think we deserve to have that granularity. Thank you.
All right, Senator Francisco.
Thank you, Madam Chair. Just another comment. I've had the opportunity to sit in on the review of the budget for wildlife and parks. And I think as part of that, we really have seen the funds that needed to go into addressing the floods that happened, is it now 2 or 3 years ago? So there is that opportunity for legislators to understand where this money is going. And I don't believe that any or very much at all of the funding for wildlife and parks is state general fund. It's these fees. So we have set a standard, I think, to be attractive, and we have that opportunity as the legislature through the budget process to make sure that we think these investments are appropriate and in line.
I think what would always help, since that's all fee based, and you're just to see how much is being used every year, because that is a big jump. 15%. Inflation is high, but not 15%. Thank God. So I would like to have that provided. If I think that's what I'm hearing from Representative Penn. If you want to respond, Senator Warren.
Absolutely, madam. That's time on target. I appreciate that help. Because again, while it may be fee-based, the fees are being paid by our constituents, and we have got to explain this to them. It has to be based in reality, and it just can't be some kind of amorphous, hey, everybody else is doing it, so we thought this was a good price point. If we actually have in the budget that there's a need, or that you guys have contracts to go out and replace the fleet, people need to understand what it is that they're paying for. And I would also ask the gentleman that is there now, what is the cap? You said that it hasn't been raised since the early 2000s. What is that cap? Do we need to go back and talk about that legislatively as well? Thank you.
It depends on the license or the permit. The caps are set individually for those in the statute.
Yes, the reviser.
Thank you, Madam Chair. I'll just note in the legislative authority memo that we write, I did actually just copy that entire statute, KSA 32988, and that contains all of those caps, and I highlighted in yellow the ones that are applicable to the changes in rules and regulations today.
Excellent. Thank you, Madam Chair. Appreciate that.
And thank you to the revisor's office for being a step ahead. I appreciate it. Senator Warren.
Thank you, Madam Chair. Just to follow up on Representative Penn's questions a little bit in my prior questions. Part of the agency analysis that's required to specifically address how it would impact or enhance or restrict business activities and growth. In answering those questions, did the department talk to any businesses, any business owners, any stakeholders across the state about how the fee increases that I guess we haven't seen in 20 years, how they might impact the industry today and going forward?
Again, and you've heard me say this before.
I think you'll need to speak into the microphone.
You've heard me say this before the committee. We often struggle to find the economic data that you would like to see, and we would also like to see. Most recently, I spoke about that when we were talking about turkey permits. We don't have specific economic information that would answer the question that you asked for. But if our historical prediction is accurate, we're not predicting a drop in the number of non-resident hunters coming to Kansas. So there should not be that kind of cascading economic impact. What we predict is that the numbers are going to remain strong and that there won't be any drop off in terms of the revenue produced.
And just to be clear, you don't have any data or information or conversations with business owners or landowners across the state to confirm or support what you've just said?
Well, if our numbers are not going to drop, there's not going to be an impact. If what I'm saying is if our historical predictions based on previous increases are accurate, and we think that they are, then there's not going to be a reduction in the number of people coming into Kansas to do business with those people while they're hunting or fishing. So there would not be an impact.
It would just seem to be hard to know for certain since the last increase was about in 2002 and 2016, I guess, and to not have those conversations. I mean, I don't understand what the harm would have been to have conversations from the department to help provide a more thorough, robust analysis rather than, well, it looks like it was this in the past. So maybe that applies today when we've got, more inflation and different circumstances to, like I think Representative Penn said, we need to live in the reality that is here today and not, we can look back, yes, but we need to know what we're looking at today as well. So again, thank you for the information you've provided and for the questions you've answered as well. Thank you, Madam Chair.
Any further questions on?
I just wanted to once again say, and I think we discussed this with talking to stakeholders, I'm not talking about talking to every single stakeholder, but getting a sampling throughout the different areas of the state, that would give you a good idea of how much it would cost for them to not have people coming in, et cetera. And so I will ask again that you keep that under consideration and you add that to your economic impact statement.
Oh, and I agree with you. I would love to have additional economic data, and I'm not talking about vague conversations that I'm talking about hard facts that have been produced by someone that's in the business of producing economic data that would answer a lot of these questions that we have. But unfortunately, that costs money because we would have to hire that done. And we're up here telling you that we need more money to keep the gas in the pickups that we use. So that's kind of the reality of it. And there's no one within state agencies in Kansas that produces that kind of economic data, because I've asked that question of tourism and the other individuals that sometimes do produce economic data. And historically in our agency, we have hired that sort of research done before. We've got an excellent study that was done on the benefit of state parks in Kansas. That was done about probably 6 or 8 years ago. Wonderful information, but it came at a price. We had to hire Wichita State University to conduct that research. So the information's absolutely out there, but we just need somebody to collect it and then produce it in a way that we know is reliable. Because again, numbers are just numbers unless they're reliable. So, but I absolutely agree with you.
Well, I think I mentioned before that you should be talking to the Travel and Tourism Department.
Yes, ma'am, I have.
What kind of information do you have on this?
In fact, the reality of that conversation is when they get a question that relates to wildlife and parks, they forward it to us. Yes, ma'am.
All right. Well, maybe if the world hears, we'd like them to try to invest themselves into finding out how hunting lodges and stuff will
Yes,
be
and
affected.
I absolutely wholeheartedly agree with you. That information would be very valuable, but unfortunately, as of now, it does not exist out there.
You have a database of all those people in Parks and Wildlife that are making money on hunting licenses? I mean, hunting lodges, etc., like Ravenswood Lodge. Do you have a database?
No,
Wildlife
because
and Parks, you have no idea.
Unless we have some sort of regulatory connection with them, then we have no reason to have that information. And so if we don't issue a license to them for some purpose, then basically not. And a lot of those people aren't regulated by the agency.
Senator Tyson.
Thank you, Madam Chairman. Jill does such a great job. I hate to add to her workload, but if making a request of when these fees go into effect, and then a 4-year, 5-year look back of the applications and how they did or did not drop off, might be beneficial. I know it's hindsight, but at least it will prove a point one way or the other.
Okay.
Thank you, Madam Chairman.
Absolutely. I mean, because we'll want to know that also, obviously. Yeah. And I think we're all on the same side of this issue because information is the key. And unfortunately, in a lot of categories, it's just lacking because the mechanism to collect it and produce it has not been there. If there are no further questions on that one, we have 4 other regs on the agenda today, and they all fall into that category that Jill presented to you on first thing this morning. These are proposed revocations of regulations that were no longer in active use. And we utilized the spreadsheet that Jill showed you this morning, and it worked very well for us. The 4 regulations that we proposed for revocation that are before you today are long not in use. These regulations date back to the 60s and probably have been not in use since probably sometime in the 70s. And if you look at the history of the Department of Wildlife and Parks, it has been reorganized statutorily 2 or 3 times in recent history. And these regulations date back to one of the prior organizations that the agency operated under. And as I say, they were designated as no longer in current use, which we attempted to find out what the legal distinction of that was. And that they were old enough so that we couldn't even find the history to see how a regulation becomes formally no longer in active use. So anyhow, KAR 23-1-2 is an old migratory waterfowl season regulation, and this was first made effective in 1966. KAR 23-1-3 relates to the open season and bag limits for doves. This also dates back to 1966. KAR 23-1-4 relates to upland birds, open season bag and possession limits. This one only dates back to 1982. And a KAR 23-2-2 squirrel season regulation that dates back to the 1980s also. All have been drawing dust for a number of years and are no longer in active use. So that's the purpose of our proposed revocation of these regs.
So are you telling me that people aren't hunting squirrels?
Oh, no, but they're just doing it under a different regulation.
Okay. All right. Are there any other questions? Representative Carmichael.
Thank you. Following up on the chair's question, there still is a season and bag limit on dove and so on. These things are covered in other regulations.
Absolutely.
Okay. Thank you.
Senator Francisco.
Thank you, Madam Chair. This is not so much a question, but I appreciated the statement that he said these are regulations proposed for revocation.
That's correct.
And so I'm looking back at our sheet, and the question we're asking is the rule and regulation being revoked? And we might, so this isn't you, this is the staff, we might want to say, is the rule and regulation being proposed for revocation? And then we're not assuming that we know what the Attorney General is going to say, that we are not assuming that there might not be a citizen that wants to come to a hearing. And it still seems open as opposed to
Correct.
being revoked. So
Correct. And as we are all aware, anything that has anything to do with a regulation has many stops. It travels greatly before it gets to the end. So yes.
It's admirable that you're getting rid of some.
Yes. Yes. And like I say,
Not only that we kind of asked you to do that, but
and the web sheet process works great. The spreadsheet process, yes, absolutely. So we're happy to be cleaning this because it's basically a cleanup of something that's certainly no longer in use.
well, we appreciate your being here. You're always very, very kind and helping us with as many questions as we have, and you don't seem to get tired of us. So
Oh no.
I do appreciate you being here. Is there anything else for the good of the committee from Department of Wildlife and Parks? Not, you are done for
Thank you,
now.
Madam Chair.
Thank you. And that means we can pause here. We'll have lunch from 12 to 1:30. Oh, Senator McGinn. We did approve it, and we noticed that we put you back on for being on. Yes, yes. Who was it? Was it? Okay. So we did find it. We did change it. So you are back in good graces. All right. Well, we'll see you in an hour and a half. Meeting is in recess. restart our meeting, I want to apologize for so many of us being gone. We were waiting to get food, and it was a little busy. So I apologize. I don't like to be late. So thank you all for being patient. One thing I want to bring up, that was our committee assistant mentioned, is that she had mistakenly made Senator McGinn as absent for that meeting, and she had flipped them. It was Representative Valdina Wynn that was absent, and so if you want to, does anyone have a problem with that being adjusted? It changes it. We probably should. I don't think we need to vote again. There you go. Okay. No objection. All right. Okay. For the second time today, we have, I get to see Alexandra Blasi from the state of Board of Pharmacy, and as well as Representative Carmichael. We won't let you leave as quickly as we did this morning.
Thank you, Madam Chair. I'm Alexandra Blasi. I'm the Executive Director for the Kansas State Board of Pharmacy. Hope to be very brief here. This is the second time you've seen one of these this year. This is an offer to emergency schedule the drug clonazepam, which is a new drug that was presented to the board by an ADA, notifying that a large quantity was identified in the state of Kansas. As I previously mentioned with the flubromazepam drug that you saw earlier this year, the board did initiate temporary emergency scheduling, which was approved by the State Rules and Regs Board this morning. And then this is the permanent regulation, though I must caveat that by saying the permanent regulation expires July 1st, 2024. The goal is for the board to exercise its emergency authority only until the legislature is able to consider the drug for permanent scheduling. Clonazepam is recommended for Schedule 1, which is the appropriate schedule for a drug that has no medical use in the United States, no known medical use in the United States. The DEA did schedule the drug on a temporary basis, which lasts about 2 years, last December of 2022. So the board feels confident. I will also note that the board has already reached out to the revisor's office, and after our meeting with KBI, we've made recommendations for an update to the the Controlled Substance Act for the legislature for consideration this next session. I'd be happy to stand for questions.
Senator Warren.
Thank you, Madam Chair, and thank you for coming to committee again. In your packet, we don't have the actual proposed regulation. Is it just a summary of it here?
It's just one line. It's just the name of the drug and adding it to Schedule 1.
Okay. And you said a large quantity of it was discovered in Kansas?
That was all the information we were provided.
You know how much the quantity was?
I do not.
Is it pill form? Is it injectable? Do you smoke it? What does that look like?
It can come in a variety of forms. My understanding is that this was powder.
Okay, powder. And do they put the powder in other carriers to distribute it and to ingest it, or how does that work?
Yes, like other illicit substances, you can do any number of things with that chemical. Usually it is being combined with other more dangerous chemicals. So for example, clonazepam would fall into like the benzodiazepine category. When coupled with an opioid, then that would cause significant respiratory depression and possible death.
And this is a new synthetic substance?
Yes.
And do we know, is it manufactured outside the United States primarily? Or?
Yes, that is the belief, yes.
And do we know where it's coming in from, southern border or?
I don't have that information. Usually China or the southern border, yes.
Well, thank you for working on this and proposing that it be included on Schedule 1. I think this is important to take a look at. Thank you. Thank you, Madam Chair.
Mm-hmm. Are there any other questions or comments? Representative Carmichael.
Thank you. I want to extend to you my apologies. I asked the question this morning, when and where are we going to see this permanent? believe me, I did review the packet, but you were right under my favorite word on the agenda, which is lunch. And so I read KDHE, I talked to Mr. Barker, and I completely ignored your permanent regulation, but is it fair to presume it is identical to what we approved this morning?
Yes, identical.
Then I don't need to review it any further. Thank you.
All right. There you go. You had to wait a long time. I'm sorry. Thanks for being here and have a great day. Now we'll move on to the Kansas Department of Health and Environment. We have, who's here? Come on up. All right, now don't all jump at once. We're not that scary. Okay. Hold on, we need your microphone on.
Oh, thank you. First off, it's my first time presenting, so
Okay, will everyone get good hard questions ready for him? So
you can go ahead and do that. I'll be ready, hopefully. Madam Chair and members of the committee, thank you for the opportunity to present on the proposed rural emergency hospital regulations. My name is Jerry Smith. I'm the director of the Bureau of Facilities and Licensure at KDHE. Thank you for the opportunity to appear before you today to discuss the proposed regulations. The United States Congress, through the Consolidated Appropriations Act of 2021, established a rural emergency hospital designation. Under the Consolidated Appropriations Act of 2021, beginning in January 2023, and only after finalization of the conditions of participation, qualifying hospitals could apply for rural emergency hospital designation and receive Medicare payment for providing emergency services. The rural emergency hospital designation is designed to maintain access to critical outpatient hospital services in communities that may not be able to support or sustain a critical access hospital or small rural hospital. In response to the passage of the Consolidated Appropriations Act 2021, the Kansas Legislature passed HB 2208, which codified the Rural Emergency Hospital Act. In establishing the Rural Emergency Hospital Act, the Kansas Legislature, yes. Sure. Okay. Oh. Would you like me to start back a little bit? No? Am I going too fast? Okay. I can start now. Okay. In establishing the Rural Emergency Hospital Act, the Kansas Legislature recognized the importance and necessity of providing and regulating the system by which healthcare services are structured and integrated to promote the availability of and access to necessary and appropriate healthcare to protect the general health, safety, and welfare of the rural residents of Kansas. The proposed regulations are necessary to effectively implement licensure of rural emergency hospitals. The proposed regulations are not mandated by the federal government. However, to obtain federal designation as a rural emergency hospital, a state may not impose stricter rules than the CMS Rural Emergency Hospital conditions of participation. KDHE has elected to adopt the conditions of participation promulgated by CMS by reference to ensure that no conflict exists between federal requirements and state-imposed requirements. Consequently, KDHE was unable to begin the promulgation process until the conditions of participation were finalized by CMS on January 1st, 2023. KDHE has consulted with and solicited information from businesses, business associations, and members of the public that may be affected by the proposed regulations. The Kansas Hospital Association has strongly urged KDHE to implement the regulations as soon as feasible. The public hearing is scheduled for November 14th, 2023 at 10 a.m. in room 530, 5th floor, Curtis State Office Building, 1000 Southwest Jackson, Topeka, Kansas. Again, thank you for the opportunity to appear, and will now stand for questions.
Do we have any questions or comments? Welcome, Senator Fauskadow. You have a question. We're glad you're here.
Thank you. Thank you, Madam Chair. I was downstairs earlier at my restrictive driver's license meeting. So I said I just couldn't be in the building without stopping by to see you guys.
We will not let you leave until the meeting's over.
What? Yeah. Oh, thank you.
She had troubles with her restrictions.
Thank you, counselor, for that correction. You're, like I said, if I ever need a lawyer, I'm hiring you. But sir, thank you so much for your presentation. So when you stated that the federal level doesn't require, however, what's happening and what do you want to happen regarding the Medicaid or the rural hospitals? Could you restate that piece?
Let me try to restate it this way. For us to be able to license someone as a rural emergency hospital, we would need to have regulations in place to do that. Those regulations mirror the conditions of participation and they do not exceed them.
Madam Chair, so the federal requirements exceed,
No, they do not exceed. Actually, the federal requirements are pretty straightforward about what a rural emergency hospital can and cannot do. There are two things that happen in this process, and I think that may be the question. For the hospital, as being a rural emergency hospital, they no longer have inpatient beds. And the reason they eliminate those is because in most of these hospitals that are pursuing this, they're maintaining a cost for 12 to 20 some beds, but their census is only 1 or 2 patients. So they're eliminating the cost of the inpatient care. And then the other part of this is that they actually receive a higher Medicare payment by becoming the rural emergency hospital. So the lowering cost, they're raising their revenue a little bit to keep them existing.
Thank you so much. Representative Carmichael.
Thank you, Madam Chair. I think I would be a derelict if I failed to mention, I believe we just had another hospital close today. Is that right?
I'm aware of Harrington.
Yeah, that's the one I'm thinking of. You know, it's been predicted that we'd see hospitals in Kansas close, and indeed it is happening. With that observation, however, is this essentially the same regulation that we saw at the Rules and Regulations Board like a week ago Friday? I see an affirmative nod from somebody in the back there.
Yes, they are.
Okay, very good then. It was a good regulation then, and it's just as good today. Thank you.
Senator Warren.
Thank you, Madam Chair, and thank you for your presentation today. I see in your report that it says REH is seen as a potential solution to continue to provide healthcare access to the areas affected by the transition. And you mean transition?
Right. So many of these hospitals are already a critical access hospital, and they're maintaining these inpatient beds. So this is just another method for them to reduce costs and rely on possibly other hospitals to provide the inpatient care. So they have to have transfer agreements and that sort of thing.
That these rural hospitals who elect to try to be licensed as REHs can remain open.
That's correct. And I've been in contact, of course, with a number of these hospitals that are considering it, and they really need to work on, their pro formas and their calculus to make sure that even if they do this, that they could remain open. What's unfortunate with Harrington is I'm not so sure that this regulation would have had any impact on their circumstance.
Your report goes on to state that often the transition to an REH is a measure to not only ensure access, but it also is a mechanism to continue to provide employment to healthcare workers and professionals. And that is
correct.
Is that kind of the impetus and the intent behind some of these as well?
That is absolutely part of it in terms of maintaining not only the access to care, but also the professionals to be there to provide the care. That's correct.
And one last question, if I may, Madam Chair. And I think in your report, it says that other states have been using this type of licensing as well. And would those be some of our border states?
So there is only one state that actually has gotten to the point that we're like number 2. I want to say I don't think it's Nebraska. It's one of the northern states that have actually licensed at least one hospital.
So we're kind of on the forefront of this.
We definitely are on the forefront. Most of the other hospitals in our, if you will, CMS conference, there's like 10 or 12, are further behind than we are.
Thank you. Thank you, Madam Chair.
Are there any other questions? Representative Wagner.
Thank you, Madam Chairman. No, it's really great to see these regulations and the state of Kansas moving forward on this. I do just want to clarify that in reading some of the details of this, that the impact of the federal law that the state is following up on is that it would reduce sort of the financial footprint of the hospital by taking away beds and that really aren't even used. And did I hear you correctly that so for hospitals, say in the 12 to 20 range currently, to become a rural emergency hospital, they would go to no beds, or they just have one or two?
So they don't have inpatient beds, but for instance, they might have an observation bed. They simply cannot keep a patient past 24 hours. Now, if they do, the world isn't going to come to an end, but they should be, if they require that type of care, then they need to transfer them to a higher level of care.
And if I may, and so part of the impetus to this is that they do get a higher, like a 5% additional payment for being in this type of system rather than being a traditional just critical access hospital. And then it's basically $3 million, it's $272,000 plus per month. Is that a standard? That's sort of a flat rate for any of the hospitals that would transition, that they would become eligible for that. Is that correct?
You know, I'm not specific. I'm not positive exactly how that is assigned. So I know that it's a higher rate, but I think you're asking for a question. You have a question of specificity of exactly what that is.
Looks like one of your colleagues can, if somebody knows,
Please come, yes. Whoever, come up and introduce yourself, whomever is going to.
Madam Chair, committee members, my name is Brian Vasquez. I'm General Counsel for the Kansas Department of Health and Environment. Basically, going to Representative Wagner's questions, you will get about $260,000 to $270,000 per month. It's a flat rate. It's a CMS payment. It is basically an inducement to go and become a rural emergency hospital. But as we've discussed in-house, is it's got to be a financial decision by that hospital, because what you're giving up are inpatient beds, because your census can't go beyond 24 hours. So you may have an inpatient bed, you may be using it as a swing bed to provide long-term care or something else, but you won't have that income source anymore. And so this is the trade-off that they have to do. Plus, you have to have a 24/7 emergency department that's fully staffed, which is where we get to some of the employment issues. But if you are a small hospital that has one ambulance and a couple of drivers, to do 24/7, that's not going to work. You're also going to have still medical professionals that are there. So it becomes a very complicated financial decision, and not all hospitals that are currently critical access hospitals will make money by moving to a rural emergency hospital. It's got to be each hospital who's got to decide that.
Thank you very much. If I can follow up a question with maybe the original conferee. And so this will go into effect in Kansas, like what is the actual start date that hospitals can switch over if they desire to? Or?
Well, the temporary regulations are, as I understand it, in effect. We do have one hospital that's been working on this for some time. The delays are in terms of them actually becoming an RH. We don't make that determination, CMS does. And we've been working with that particular hospital for many months. And the moment that CMS, they've given them a pending letter. I'll put it that way. When they actually come to the point that they have met, that they believe this hospital has met all those requirements, then it will be backdated to 8/8/28 will be our first hospital, August 28th.
And if I could also, Madam Chairman, just follow up question. I'm very much aware from just earlier discussions about rural hospitals in this building that there are approximately 40 critical access hospitals that their average daily patient count is under 2. It's like 1 person or 0 per night. And so does KDHE have any sort of estimate as to how many of those hospitals that they think would plausibly transition to this, this rural emergency hospital? I mean, is there any estimate, or it's all just a guess?
There was a lot of chatter about many who are considering it. We have one that is nearing the end of the process, as I described, and we have one other that has submitted a letter of intent. So far, 2.
Thank you.
All right. Are there any other questions? Okay.
Thank you very much.
Thanks so much for being here. We'll move on to doesn't say anybody's coming up to speak to us about this. And I'm assuming since you're lurking in the corner that you'll come up. It just said written only. Oh, it's up above it. Oh, Joe, you must be Joseph Dorn.
Joseph Dom.
Don, thank you for being at committee. I appreciate you being here, and I'm sorry that I think I've been drinking through my lunch. I have not. Lots of water, but not anything else. Welcome to committee, and you can introduce yourself and tell us what's going on.
Thank you, Madam Chair and members of the committee. My name is Joseph Dom, and I'm a section chief within the Bureau of Environmental Remediation at the Department of Health and Environment, and I oversee our spills program. Joining me today, I have Mr. Randy Carlson, our Bureau Director for the Bureau of Environmental Remediation, and Ms. Emily Quinn, an environmental attorney with our legal services. I thank you for the opportunity to present our regulatory revisions today. The regulations we are discussing today are Kansas Administrative Regulation 2848 at sequence, which involve the response and reporting of the release of pollutants to the soil or waters of the state. The article currently requires the owner or person responsible for the discharge or escape of the pollutant to immediately report the discharge or escape to the Department of Health and Environment. This article was last amended in May 1986. Article 48 does not specify what quantity of a pollutant, when released, must be reported to the department, meaning that releases as small as a drip or a drop are required to be reported. This creates an onerous requirement on the responsible party to notify the department for every spill, regardless of the volume released, even when that spill is quickly and easily cleaned up and poses no significant threat to human health or environment. This requirement also created confusion amongst the regulated community as to what is required to be reported, since the reporting requirements in Article 48 are not consistent with the reporting requirements of other state agencies or the federal reportable requirements for oil and hazardous substances. Additionally, states adjacent to Kansas have adopted the federal reportable quantities, leaving Kansas as an outlier of stringent and inconsistent spill reporting requirements. The proposed changes to Article 48 clarify who is required to report the release, what actions the person responsible for the release are required to take, and adopts minimum reportable quantities for when a release must be reported to the department. We have met with representatives from the U.S. Environmental Protection Agency, municipalities, environmental consulting firms, and the regulated industry to develop science-based reporting requirements that are representative of actual human health and environment risk. Meetings were held formally with the entire stakeholder group to solicit input and feedback, and discussions were held individually with representatives when we were present at other meetings, such as the Governor's Water Conference, Kansas Environmental Conference. As the proposed regulations were drafted, emails were sent to our stakeholders for their review. And we also presented these reportable quantities to the Commission on Emergency Planning on Response to garner feedback from the emergency response community. Generally, the feedback we received from our stakeholders was that they wanted to see reportable quantities consistent with both the federal reportable quantities and those required by other state agencies. As required by KSA 77-416, the department has provided the Kansas Association of Counties, the League of Kansas Municipalities, and the Kansas Association of School Boards with the proposed regulation changes, the notice of public hearing, the environmental impact statement, and environmental benefit statement. The hearing date is scheduled for December 15th, 2023. I will pause now for any questions from the committee, unless you'd like me to go into each section.
Senator Fausto.
Thank you, Madam Chair. So would you clarify for me, please, when you say it must be a self-reporting of a spill or the toxic fume, is it just on that person's property? Or would they also have to report a spill that from a third party had nothing to do with them or their property? Could you just explain that to me? Thank you.
The way the regulation is proposed, the responsible party is required to report that release to the agency. However, there are going to be situations when we may not have a responsible party. The responsible party may be incapacitated, such as automobile accidents or industrial type accidents. So other parties are permitted to report those releases to the agency. We can get them from emergency managers, law enforcement, individual representatives, citizens. Yes.
Are there any other questions or comments? Does anyone want him to go through all of the different sections? Well, we just might. No. Thank you so much for being here. I think taking care of business. Thank you so much. Oh, I'm sorry, Senator McGinn. See, I caused that to happen.
I was just curious. So you have to report within 24 hours. When does the agency, when do they have to respond back? Because I assume if it's a number, it's going to be a recording.
Our 24-hour spill hotline is manned 24/7. There will be a person at the end of that call. We'll collect the information from the reporting party. And depending on what the risk is to human health or environment, we'll either wake up people in our district offices to go out to respond to a release. If it's a minor release, we may wait until the next business day. If it is a release to water, particularly waters that are used for public water supply, we will respond either that day or the next day.
But you won't be responding a week later.
There may be situations where maybe a week later, yes, depending on what the
I think if I have to tell you in 24 hours, you ought to get back with me in 24 hours.
Sorry, can you say that again?
I said, if I have to respond to you in 24 hours, I think you should have to get back with me in 24 hours. You said you've got a live body on the other end and you'll pull them out of bed if you need to. I just don't understand why, because on my end, I might be worried about it. And I would like somebody to say it'll be okay. Or you might want to try some of these kinds of things and we'll be out there in a few days. That's because it's stressful to have if that happened to you. So people that use chemicals. Just a comment. Thank you.
Thank you. Senator Tyson.
Thank you, Madam Chairman. Well, thank you, Senator. You actually opened a can of worms with the department. I have a friend that has been trying to get, I know it's not you guys, but it's KDHE, a well permit for over 6 months. And the back and forth, the lack of response. So I can't imagine them responding within 24 hours on a chemical spill. But thank you, Madam Chairman.
Representative Carmichael, and then Representative Wagner after that.
Thank you. There was a spill in north central Kansas from a TC Energy pipeline. Perhaps you recall that event.
I am familiar with the event.
And was KDHE notified of that event?
We were notified of the event, correct.
And how long did it take you all to respond to that event?
I believe we had someone from our district office on site the following day.
Yeah, I had heard that you all arrived shortly after the sun arrived, that you were there very promptly. So assuming that's the case, I appreciate it. Thank you.
Representative Wagner.
Thank you, Madam Chairman. I'm looking at 28-48-3 on reportable quantities, and I just want a little clarification. So, this is some of the change, and I appreciate the fact that you're actually specifying amounts. But am I reading this correctly that under C on gallons of oil, it's like 25 gallons of oil? So if somebody had like a 55-gallon barrel, in their next to their garage or something that was half full of used motor oil or whatever that they had dumped there the last year or two, whatever, that would be a reportable. I mean, if they I don't know, got knocked over and oil, whatever, it sat all night and the oil all came out, that would be a reportable quantity. Is that correct?
That is correct.
Really? And that's regardless of whether it's near water or any surface water sensitive. It's just anywhere just hits the soil, that's reportable. Wow. But as maybe somewhat onerous is, I mean, I don't know the pollutant effect of that, but prior to this, it would have been 1 gallon. If it would have spelled, it would have been considered reportable. But now you have sort of a specified amount.
That is correct.
Okay. All right. Thank you.
Yes, continue.
Just follow-up question. So if I was a auto mechanic, shade tree mechanic, or maybe I had a gas station, and so what is the fine? I mean, what is the fee if they don't report? I mean, how much trouble do people get into with this? I mean, how does that work?
The statute permits the agency to issue fines for not reporting.
Of how much money? I mean, does it depend on how big the spill is, or?
It would depend on how big the spill is, if there were attempts to cover up the release.
Okay. If I may just, so let's say they didn't attempt to cover up, they just didn't report it. They just said, this is not a big deal, and somebody else noted it and called KDHE. I mean, is it a $500 fine, a $1,000 fine? I mean, how big is the hit on somebody for,
If I recall correctly, I believe the statute specifies $5,000 per occurrence and up to a total of $15,000.
Okay.
Senator McGinn.
So is there a fee schedule somewhere?
We do not have a fee
Or I
schedule.
mean, yeah,
Or fine schedule.
fine schedule.
We have been working on one, but we have not finalized it yet.
Okay. Well, I know, like, if we overuse our water, I mean, it's all mathematically figured out how much water I overused, and here's my fine. And that's in the rules and regs books for the water folks. I just think that should be public. You said you've been working on it. How long? Like a week or?
We've been working on it since the initiative to revise the statutes was started.
So when could we expect that to be taken care of?
As soon as I can work on it. I hate to put a time on it, but
somehow I knew that there's something I would hear that. Would you please let this committee know when you get that done?
We will.
We would really like to know that. So you have another question?
Just a comment. So a concern I'd have is if, Representative Wagner spilled 25 gallons of oil and I spilled 25 gallons of oil, would he get fined 5,000 and I get fined 10? I mean, I'm just trying to find out some equity here and make sure we're fair to everybody. Thank you.
I'll be honest, and I'm not just picking on you. I think a lot of times we forget that we actually all work for the taxpayers. And the more transparent we can be and more accountable we can be, the less that they'll say we have too many people telling us what to do. So I think it's a really good idea to have as much information out there as possible. So we would really like to know that. Representative Wagner.
Thank you, Madam Chairman. Again, thinking about this, so if somebody calls on the 25-gallon oil spill, I mean, how do you remediate it? I mean, is that a service you guys offer, or there's private agencies that will, I don't know, scoop up all the dirt and replace it with new dirt? How what's the cost of that?
The responsible party would need to contract with an environmental consultant or environmental response company to complete that. And it would vary based on location, what needs to be done to remediate it. It could be as simple as removal from the soil, or if it has been in the ground and gets in deeper into the ground, there are other technologies that may be used.
If I may, is the fee schedule something mandated by the federal government, or this is your guys' schedule? Like KDHE came up with their own notion as to what the fine should be.
This is a schedule that we are working on. It's
okay. It's an internal. It's not mandated by some federal statute or some state statute. This is your.
It's in the state statute.
Oh, it is
the fine.
Yes. The fine level is. Oh, it is. And we passed that. When did we pass that? I mean, is this like an old law, or is this something we recently passed?
We have a reviser that wants to tell us a little bit. So yes.
Thank you, Madam Chair. The statute is KSA 65171V. It would be subsection E. The latest update was passed in 2021. It says, upon a finding that a person has violated any provision of this section or rules and regulations, the Secretary may impose a fee not to exceed $5,000. In the case of a continuing violation, the maximum penalty shall not exceed $15,000. And this would also allow for a penalty not to be imposed until after due process. So a hearing and or a notice and an opportunity to be heard before the fine is imposed.
If I may, so hearing the words of the statute, it may not exceed that as far as what the statute is. It's like you guys don't have to have a $5,000 fine. You have a $1,000 fine or something, whatever. But that's, I take it that's just a rules and regs decision from your guys' standpoint as to how high up the, if you're going to go 100%, or you're going to go 50%, you're going to go 10%. This is just an internal decision.
We would work with our legal counsel to determine the appropriate amount.
Okay. I mean, I will say, just as it seems somewhat onerous. I mean, I don't know. It strikes me as this is, if I was running a gas station, or even just, I'm thinking more shade tree mechanic type people, or people who on farms who work on their own equipment, do their own oil changes. I would think a lesser amount would be more in the public interest.
Representative Carmichael.
Thank you, Madam Chair. It is important that the legislature set the outside parameters of what type of a penalty ought to be imposed. In this case, that outside parameter sounds like it's $5,000, but there are provisions for continuing violations. Let me tell you an anecdotal story. Prior to the passage of this legislation in 2021, there was a member of the state legislature who, unbeknownst to him or her, and it wasn't me, was in violation because those old 55-gallon barrels that had probably been there when he acquired the property, someone discovered they had something in them. And KDHE came out and looked, and the end result was that he did pay to remediate it, even though it wasn't his barrels, it was on his ground, and he didn't want his groundwater contaminated. And he remediated it, and no penalty was assessed. The situation hasn't recurred. The public's been protected. The environment's been protected. And by giving the agency the discretion to not always lower the hammer on people, even though it was a state legislator, the problem was taken care of. And we have to give these folks some discretion, and I don't mind seeing guidelines of one kind or another. If you spill 100,000 barrels of naphtha into the Arkansas River, I think somebody probably ought to be in trouble. But I think we do want to give agencies some discretion to work with people to clean up violations and make sure they don't reoccur, as opposed to always just relying upon monetary penalties to accomplish a purpose. So that's just my observation about schedules. And I'm sure you'll take that into account in developing one.
Yes, sir.
Is there anything else for the good of the committee at this point? Thank you for being here. I'd like the committee to also note that we have written testimony from Randy Stuckey. Randy, would you like to come up, sir, and say anything?
Good afternoon, and thank you, Madam Chairman. Randy Stuckey on behalf of the Kansas Grain and Feed Association and the Kansas Agribusiness Retailers Association. So our associations are heavily invested in the process, working with KDHE over a number of years now, both informally with multiple stakeholder meetings on this issue over multiple years, leading up to the changes in statute that Senator Francisco helped wordsmith, I think, quite a bit along the way. We appreciate that, getting the language right. But the overarching theme here is to make sure that the statutory changes allowed for both safety and environmental assurance, but also recognizing that some of the current status of the spill notification requirements at the time were much more burdensome than even the U.S. EPA. And so in other states, and as Mr. Dom stated, we want to make sure there was consistency there for both environmental assurance, but also not to be overly burdensome on the regulated industry. And so having passed the legislation a few years ago, and now the secondary step of adopting the regulations, which point to the US EPA spill notification requirements, is a great move. We appreciate it. And KDHE, I just want to say, I want to herald their work. I think they did it right. For many years, they sat down with industry and said, is this important? And how can we best approach this issue? And they held multiple stakeholder meetings and then worked with us on language in the statutory changes and then the regulations too. So appreciate that approach by the agency for sure. Very quickly, as to the penalty piece that was just discussed, that was a piece that was discussed at length in the statutory changes. And putting that $5,000 maximum, we're not individuals. I represent agribusiness, very, very large industry. And so we thought the $5,000 per day was not probably too onerous, taking into account that KDHE has that discretion currently if they're not going to whack somebody for an incidental or an unintentional spill. But if we have a bad actor, even from our industry, we want to make sure that person that situation is addressed. And so if you have to do the maximum for an intentional or negligible incident that is not addressed, is not cleaned up, we wanted to make sure that the agency had the authority and the tools to address that situation and that bad actor. The $15,000 maximum penalty was for those ongoing penalties or ongoing violations. We thought $15,000 was probably a big enough tool to address an ongoing violation. But I do take the comments into account where, maybe either through regulation or an informal document within, like a working document within KDHE, to at least spell out for the regulated community, this type of violation warrants this type of penalty. And then the secretary can move away from that with cause. Other agencies do that all the time. Department of Agriculture does that routinely, and even worked with the regulated community on what we thought might be an appropriate fee schedule or fine schedule to address those things. So again, that's all we had to say. We appreciate KDHE bringing all along the way, both the statute and the regulations, and we'll continue to work with them if there needs to be some changes to this proposed regulation. But it took them a while to get here because the process takes a while now. So we appreciate their work.
All right. Well, thank you for coming up and speaking. I appreciate it.
Thank you for the time.
I did want to know if WAC is a agribusiness term, and if you could define that. I'm sorry.
I think if they get that penalty in the mail, they'll feel whacked, I think. Very good. All right.
And I would also like to thank KDHE for contacting stakeholders, emailing them, asking them for advice. And I would like to point out to the Department of Wildlife and Parks it wouldn't be hard to email stakeholders and get some feedback on some of the things that they're doing. But apparently they don't feel like they have to do that. So that's just my little public rant. And I might call the department and tell them that. So thank you all for being here. I appreciate it. And you are off the hot seat, and you may leave if you want to. It's not like church where you leave early, you get in trouble. We now go to the. Oh, I'm sorry. So I'm sorry, Senator Francisco.
We're on to the Department of Wildlife and Parks. So I have been to some of what I thought were quarterly meetings that the commissioners have in various communities around Kansas. And the whole point is for them to talk about this is what we're proposing and what's your response. And the 3 or 4 meetings I went to had good turnout and interesting discussion. So I don't think it's that they're not reaching out in some way, but they do have the commissioners have a very structured way to get some of that.
But like I heard from Kate, we just heard, I'm sorry, from KDHE that they email stakeholders. So they email people that are involved in this and they get their feedback. And I think that everyone should be able to make up an email list, alert stakeholders or people that have a great interest in what's going on. So I'm just being.
It would be interesting to find out what kind of organizations represent those groups, because certainly having an agribusiness set of people that all are getting that information and working with the lobbyist may be a lot easier than if there's not that. But I'm sure, and I will keep my eye out for groups that might be appropriate for such contact.
Okay, that sounds great. Thank you. All right, then we'll move on. Now we'll go to our final people, right? Secretary of State, the Secretary of State's office, and welcome to committee, sir.
Thank you, Madam Chair. I'm Clay Barker, General Counsel for the Kansas Secretary of State, and I'm here for 2 purposes today. One is to go over a expedited revocation of an election statute, and then second, discuss 11 what we feel are pretty minor amendments to notary regulations. And first of all, if it's okay, Madam Chair, I'd like to go over the expedited revocation of the election regulation first, if that's all right.
Yes, you may.
All right, so procedurally, once the legislature enacted the law to have us review all the regulations, the Secretary of State's office was in the first group that every 5 years has to look through them. The standard we were given by the statute was to determine whether a regulation is necessary, and that's the key word, for the implementation and administration of this state law. So we went through all 114 regulations that our office has issued. That's 64 in the business area, 45 in elections, and 5 on fees, asking, is each one necessary to operate? And we flagged a bunch that'll need to be amended, and those will be coming down the pike soon. But we only identified one that was no longer necessary. Procedurally, where we are in that is to eliminate, with this expedited process, I know you discussed this morning, you just publish the revocation in the Kansas Register, and 15 days later, the regulation goes away. But before you can publish in the Register, you must accomplish 3 things. First, give notice to the Attorney General and get their approval, which we did. It was approved the 12th of September. Second is to notice this committee, and if the chair asks us to appear, which is why I'm here today. And third, if a member of the public sends written requests that you hold a public hearing, and as you discussed this morning, there was no mechanism to inform the public so they know to ask for a hearing. We saw that as an implied task that each agency must do and use just reasonable means to notify the public. And probably tomorrow, Laura and I will draft up an email that we will send to those individuals who have indicated to our office, we have a list, that they're interested in Secretary of State regulations. And that'll go out explaining what's being done, give them a certain amount of time to ask for a hearing, and if none is, we'll publish in the Kansas Register. Okay, so moving on to what is this regulation? It's a very simple regulation. It says advanced voter lists shall be subject to the provisions of 2 statutes. And it was first adopted in 1994. And these 2 statutes, one of them was actually repealed in 2003, but I believe it was replaced by a KORA statute that says the information on the voter registration list cannot be used for commercial purposes. You can't sell it. You can't use it to go advertise your product except for political campaigns and election purposes. And the other statute essentially says the same thing. Information on or derived from voter registration lists cannot be used for commercial purposes. So the regulation was saying you can't use the advanced voter list for commercial purposes. Now, in 1994, when this was first adopted, this is back when counties kept their own voter registration list. There was no state unified list. And the voter registration list and the advanced voter list were 2 tangible, separate lists. So the logic with this regulation was we took a statute that applied to voter registration lists just to make it clear to the counties it also applied to advanced lists. Time progresses. The voter registration list is now combined at a database at state level. And this essentially made this regulation no longer necessary. Now it duplicates the statute because everything is in the voter registration list. So the statute can stand alone. The regulation is no longer necessary. It was probably no longer necessary 20 years ago, but we didn't flag it until we did this review. And that's why we are asking to have it revoked. It's no longer necessary. It duplicates the statute.
All right. Are there any questions or comments? Senator Fausto.
Thank you, Madam Chair. Just clarification, Clay. So in order to do this, you stated at first that you go through a step first and then it's gone. It's eliminated. Oh, that was the.
Senator, the way the statute's set up is it says you publish in the Kansas Register and 15 days later it's gone. And the next part says, but before you can do that, you must do these 3 items: Attorney General, JCAR, and public hearing if requested.
Representative Carmichael.
Thank you. And Mr. Barker, I appreciate you taking the time over the weekend and even a holiday to answer my questions about this regulation. I appreciate that. How much does it cost to publish something in the Kansas Register? If you're qualified to, to submit things, how much does that cost?
Representative, it depends on the space, like a newspaper ad, and $7 per column inch.
Okay. Part of the reason I was wondering is there might be some discussion about maybe making for a dual notice provision to require publication of an intent to go through this process. And I was just wanting to get some rough ideas to what that would cost, and $7 a column inch.
Thank you, Representative. We don't make a profit off the Kansas.
I didn't think that you did.
Representative Penn.
Thank you, Madam Chair. Thank you, Mr. Barker, for being here today. On the heels of the ranking member's question, it did spur something in my mind. We had originally done something, I forget what it was. That's what it was, when we had local municipalities, before they did any increasing to mill levy rates or anything like that, or appraisements, there it is. They appraised values of homes in order to raise taxes. We had them, there was a time that they had to publish it or put it out to the public, to their landowners and everything. And they had to publish them in certain venues. There was some discussion down at the county level at one of the county commission visits that I took, where they were discussing about where there should be in a record of what's called a publication of record, and if that was indeed helping them to keep their business afloat, or should it go into something that was more like a social media or some type of site like that, where it didn't cost as much but had bigger reach. I would be interested to know, either from the Secretary of State's office or any of the other agencies, if we were to go back and address this, what would seem reasonable for that notification, both the mechanism, the venue, or the mode. Thank you, Madam Chair.
Thank you. Are there any other questions or comments? And I believe you can move on. I don't see any.
All right, Madam Chair, we'll be sending out our public notice, but there will be notice tomorrow probably, or maybe the next day. Moving on to the notary regulations. Briefly on the chronology of this helps understand why we're doing this. In 2021, the legislature removed all the old notary statutes and replaced it with the revised Uniform Law on Notarial Acts. And that took effect January 1 of 2022. And that was a little faster than was in the original bill. And then our office sat down and wrote regulations. And one of the statutes in this act is a very long list of specific things that regulations must be written on. It's very detailed. We got those regulations, the old regulations revoked, and the new temporary ones came into effect June 2022. So we actually had a period of time when the statutes were there, but there were no regulations, and we had to work with the notaries on that. And the permanent regulations came out in October of 2022. And then between the temporary and the permanent, the attorneys from the National Notary Association, it's a well-respected organization, sent us a list saying, we have some suggestions for you. And they were small wording changes. And we made the decision that we would go ahead with the permanent regulations because we didn't want to leave the notaries waiting, and that we would take up these changes later. By late 2022, we had reviewed all their suggested changes and talked to some lobbyists that worked with notaries and notaries around the state. And we suggested 11 amended regulations, and we submitted them into the process for a regulation at the very end of 2022, beginning of 2023. But we told the Department of Administration, the Attorney General, because they had a lot of regulations, this was not a priority for them. These aren't material changes, it's wording changes, which is why it took until now before this is coming before you. Our public hearing is scheduled for November 20. And again, these are they're small wording changes. Sometimes the order that the regulation was written in, we made paragraph A now became B and B became A because it flowed. Sometimes just explanations on the words, and just having an outside intelligent editor helps make the product a lot better. And again, there's no substance change to any of the notary regulations. Again, it's just wording changes. But we've been told by the field that these are good changes. And Madam Chair, I know you're interested in the journals for notaries. These got put into the notary or the regulation system before we started working on that. That's why the journal's not in here, but the journal is still an issue. And we may have to tweak the statute on the journal somewhat to get the goal. And the chair's goal is that the statute now requires every notary to keep a journal, whether it's electronic or physical. And this is because there's problems sometimes in court cases where someone says, well, I wasn't there when this was notarized. And the notary says, that was 5 years ago. I don't remember. I don't keep a journal. And now that journals are mandatory in some areas, especially law enforcement and government, the notaries feel they're being overwhelmed by the number of notarizations they have to do and keeping up with it. We're trying to come up with a way to make it a little less burdensome on them. But that's, again, not in these regulations. I just want to let you know we have not forgotten your request.
Certainly appreciate that. And then you also have to keep them for 10 years.
Yes, they must be kept for 10
So
years.
I think if you want them to keep it that long, that you should be the repository for all the records, and then you can pull them out. So try bringing that back to see if, offices, title offices, right, law enforcement, they've got multiple books with this in 1 year. So to keep them for 10 years is a large ask. And I also appreciate that nothing in your subsection for 74313 shall be construed to prohibit a notary public from using multiple stamping devices. I'm glad you added that because I have one old one here in my office in the Capitol, and I have a newer one at home. So thank you. It still has my same name and everything. So I'm glad that's added so I don't go to jail. And I did notarize something the other day and I didn't keep track of it. So I can go to jail for that. But
Madam Chair, I'm open to questions on any specific amendments, any of the notary regulations. Again, nothing of substance, so there's really nothing to explain.
do you want to, why don't we just open up for questions? So Senator Warren.
Thank you, Madam Chair. And Clay, it's always good to see you, my neighbor up here at the Capitol, in addition to walking my backyard sometimes. So glad to have you here.
Not trespassing.
Not trespassing. No, there's a public path behind our backyard between our two neighborhoods. So
Well, that's important to add.
it is. Regarding that same regulation 743.13, this isn't a new change, but just for a point of clarification while you're here and while we're talking about it, subparagraph B talks about that the official stamp shall provide a space for the notary public to record the notary public's commission expiration date. Oftentimes that's a blank line and the notary public would write it in. There's nothing prohibiting the stamp manufacturer to go ahead and make that part of the stamp. So you just stamp it and it's on there, and you have to get a new stamp each time, of course, but shall provide a space to record. So as long as it's on there, you don't care if it's you write it in on the blank line or if it's printed on the stamp.
Correct, Senator.
Okay, great.
And we are the administrators of the state's notary program. They apply through us. We keep large databases, make sure they have a surety bond, a record of the stamp. But other than that, I handle complaints. If a notary does something wrong, we really aren't the notary police. Sometimes people ask us for legal opinions, and I have to tell them I can't give you that. I can reference you to the statutes and regulations, but my opinion on notary law and $2 will get you a cup of coffee. But
well, I have some questions about some of the laws that probably wouldn't be something you would answer, but there is a proposed change in the next regulation, 743.14, and it says in subsection A, any notary public shall affix an official stamp to a notarial certificate. Should it be a notary public? It seems to me then that it doesn't have to be the notary public who's actually doing the notarial act. It says any notary public can come and stamp it. It doesn't necessarily indicate that it has to be the same one actually doing the notarial act. And maybe that's just, it is kind of,
Does sort of read like that.
so
So
I
I
would,
could come in off the street.
just to clarify that a little bit, I would ask you guys to take a look at.
got it. Thank you, Senator.
And some of these are some 743.17 regarding short form notarial certificates, the statement that needs to be on there for acknowledgement in a representative capacity and things like that. I have questions about, this isn't a question for you, I'm stating it anyway, that if you're acknowledging as the notary in example 2 there, that the person you're notarizing for has the authority as the officer or trustee, I mean, then the notary is saying, I'm making some affirmative statement that this person has that legal capacity to be the trustee or to be any other type of authority or an officer. And again, that's not a you question, but maybe something the legislature should look at. Is the notary public then liable if the notary public is wrong? And I would then also look at power of attorney. Is the notary liable if the notary is wrong, that this person really didn't have a valid power of attorney? And unless
Senator,
we've
in those
addressed that
cases-
already.
In those cases, the notary is only responsible for making sure the person is who they say they are. So if it's Clay Barker, they'll look at an ID or they know me. They don't have a duty to ensure the person actually has the representative capacity, though that's what's represented to the notary, or that they have a power of attorney. And so the person has to say, I have a power of attorney and I'm, again, Clay Barker, here's my ID. And that's what the notary verifies. But they put the different certificate on to indicate the capacity the person claims to be signing in.
Right, that the person is asserting their capacity, but the notary isn't making any comment on that they're just verifying Sarah Smith is Sarah Smith, regardless of her other capacity or what other hat she's putting on.
Correct, Senator. And I get complaints occasionally where someone will say, yes, I signed this document, but the contents of the document were incorrect. And it's the notary's fault. We say, no, that's not the notary's duty. And this these statements at the end of the document are supposed to be drafted by the person who drafts the document. So they should put the right acknowledgement down there so the notary only has to verify the person.
And we have it clear in regulations or statute that when you're asserting, the state and the county that the notarial act is occurring in, it's where the notary is sitting if it's a remote notarization, right? And the notary is sitting in Kansas as required by statute. And regardless of where the person signing is, the state and county are going to be where the notary sits.
Correct. It's where the notary is physically located. So the people don't have to be in Kansas. They could be quite remote outside the state, but the notary must be physically in Kansas.
In theory, then Kansas law would have some say over if there's a dispute about the signature or the act, or I guess it's up in the air if it's New York law or Indiana law or whatnot. If the person is fraudulently asserting they have some authority they don't, whether we prosecute that here in Kansas or in the state where the person is making the statement.
I'm sure there'd be lots of choice of law issues.
Oh, yeah.
If it's a notary issue, it's Kansas law would apply because the notary's in Kansas and a Kansas notary.
That's right. And is there something in the regulations about where you get trained to do electronic notarizing and for remote notarization?
Senator, we have online training for anyone that wants to do remote notarization. It's free. You can get it through our office. And then usually the vendors also give training on the specific ins and outs of their system. Usually a remote notary has one vendor they use.
Because I remember when we were looking at the Uniform Act and revising all this in 21, there was some concern about how are you as a notary going to learn to make sure that we're verifying and they show the identification on the camera, and you've taken care of that in regulations and the training online, correct?
Correct, Senator. There's a lot of detail in the regulations about how you identify the person over a screen. It's a little bit like a Zoom meeting, but it's more enhanced. And then again, we give training and then the vendors give training to the notary on how to use it. And I found out the hard way that if you do one or two searches on YouTube for remote notary, you'll start getting bombarded by ads about get our system, make $500 a day laying on your couch, things like that.
Well,
Never tried it.
Thank you to the secretary and the office for putting this together, because it's brand new in Kansas and we want to make sure that we get it right and protect the public who's relying on the notary public officiating over this and making sure that we have some valid processes in place so that you can rest assured that the signature that's been notarized is who the person said they were. So thank you. Thank you, Madam Chair.
Any other comments or questions? Senator Fausto.
Madam Chair, thank you. And I wanted to let it in with Senator Warren's great comments and information we just heard, but just clarification on that same 7-43-13, when it talks about if a stamp has been stolen or lost, that you use a different one. Is it just you put a groove in it, a little comma, just anything to make it? Can you explain that part?
Senator, what we've suggested to notaries when that happens is if you had for instance, a rectangle stamp, get an oval one. So it's easy to tell that you now have a new stamp. So if the old one is used, and I have a case in front of me right now, nothing I can do about it because I don't know who the fake notary was. They took someone's stamp and stamped a mortgage and then filed it. And the notary says, it wasn't me. I reported it stolen like I should have. I have a new stamp.
Is there money? I mean, I've never gotten any money for being a notary. Is there a lot of money? I mean, but why would I know what they would do it for bad purposes, but.
It seems to be mortgage fraud. Sometimes they'll stamp something for a deceased or elderly person. And by the time someone realizes that the property's been sold again or something.
All right. Thank you so much for being here.
Thank you, Representative.
Okay, let's go back over and see if anyone wanted to add, see what comments that we had that maybe Shelley saw from KLRD, and if anyone wanted to add anything. So I'm going to give the floor to Jill at the moment. Okay.
Thank you, Madam Chair. Jill Shelley, Legislative Research. Regarding the first one I had highlighted in my notes is with the Department of Wildlife and Parks. Senator Tyson had requested a 4 or 5 year look back on changes in licensing and the revenues associated with those.
There was nothing for the Department of Revenue. I was just going to go through the agenda and try to see. With the Department of Revenue. Okay, Jordan, then you're on. Lucky you. Okay, and if anybody remembers having a comment about revenue, speak up. All right, continue. Oh, very good, yes. Is that accurate? Senator Tyson, that was yours.
Yes, but I don't know if they can do it until we actually have the fee increase. That's what we wanted to see, is unless somebody wants to look back now just to see what the trend is. That was the idea, was to see how the increase will impact the applications.
Oh.
Thank you, Madam Chair. I believe, just to clarify, was that statement with regard to the Department of Wildlife and Parks permits?
Or KBI?
I was hoping to ask about the Bureau of Investigation.
She was talking about the KBI.
So I can repeat that highlighted statement I had down for.
Yes, she misspoke, so that's okay. That's what, yes, and that's what she wanted to add to it.
Okay.
Could
Question about the jurisdiction.
Thank you, Madam Chairman. Yes, KBI, I don't know, and like I said, there's probably others that do understand, but when is KBI have the authority to go in? Does it have to be a local that calls them in?
Right.
Are there other ways that they can be called in?
Perfect.
Okay, if it's okay with the chairperson, I'd move on to Board of Examiners and Optometry. I did not have any.
I did have one quick question that I don't know if it's proper in this committee to have it reported back, but I had asked a question whether the approved field tests that were being promulgated in the regulations, whether those were the same type of test strips that the legislature had approved for decriminalization, if the KBI would be able to answer that question.
Thank you, Madam Chair. I've got a note about the test strips based on that statement. Thank you for the reminder.
Thank you.
All right. State Board of Optometry.
Thank you, Madam Chair. I did not have any comments for the State Board of Optometry.
EMS.
Thank you, Madam Chair. Looking at EMS, I believe there was an ask about their fee fund, how much money in an unencumbered funds was in that fee fund. Also there's a question about what the agency does with the funds. I know that Executive Director House stated that there usually aren't direct appropriations for that. But if it's the will of the committee, we could make sure to ask that to get it in writing.
Okay, great.
If I may, before we move on to Department of Wildlife and Parks, during the KBI discussion, there was a lot of discussion about expungement of the DNA records, and I didn't know if there would be any comment in the minutes about automatic expungement of the DNA in particular, that maybe that's something the legislature should look at, or if those are proper type of comments from this committee or in this report. Don't know, but it was part of the discussion. Thank you, Madam Chair.
Moving on to Department of Wildlife and Parks then. So there were a few statements I had highlighted in my notes. The first was regarding deer baiting, asking for a response from the secretary on that particular topic. And then also about the out-of-state permits, asking that the agency provide some commentary on their objectives in changing the rules regarding out-of-state permits. And then finally, Senator Tyson had asked about that 4 or 5 year look back. So I'm not sure if this is something that we would want to ask about, if it was the intent of the committee to ask about what had happened since the last change in 2016, or if this was something they were wanting to request a look back on down the road after this change is implemented. So I guess that'd be a clarification to make, whether they would want to ask for that data at a later point, or if they would want information since 2016.
Did you want to clarify that?
Thank you, Madam Chairman. Mine was to look at it after the increase with a 5-year look back or 4-year. But if anybody wants to see that data before the increase occurs, that's fine.
And perhaps add that I would like them to try to get up a list of stakeholders that we talked about with hunting lodges to see if how they're affected by some of these changes. That's right. And I know we can go with Ken. Oh, Senator McGinn.
Thank you. I think I'm going to go find my bill from about 5 years ago that where I wanted all outfitters and what's the other name they're called? No, it was just the outfitters and the scouts and all that, those businesses to be registered on Wildlife and Parks. So I wanted it because I have everybody knocking on my door and they have an out of county tag. And I ask them if they're a guide. And seems like no one was a guide until I found out later from another person. So if you had them registered, then you could see what you want to see. But see what you want to see. You can look at the trends. So anyway, I may go look for that again.
Senator Tyson.
Thank you, Madam Chairman. That reminds
Things
me.
we dredge up in this committee are great.
That reminds me of the roofers registration that we passed. That I did not support it, still do not support it, and has not saved anybody from fraud. And all it's done is created a burden for our small business owners. And let's talk scrap metal dealers. So
No, not today. No, we're just about done. We're not going to bring up that. Thank you.
Madam Chair, may I run some language by the committee? Would that be appropriate on the registry?
Absolutely.
Okay. So I would write it something like, other agencies that have brought rules and regulations before the committee have discussed their contact with stakeholders that may be affected by these rules and regulations. The committee would urge the agency to develop a list of hunting lodges or other similar businesses related to hunting in the state that may have some desire to be contacted on future rules and regulations changes. Something along those lines.
You are so politically correct. I'm very impressed. That was a lovely way to phrase it. Thank you. Great job, Jordan.
So that list is not suggested that it's a required, but
No,
if the entity wants to be contacted, they would voluntarily sign up for that list. Thank you.
Thank you, Madam Chair. Yes, So the way I was phrasing it or had it in my head would be that the committee would be urging the agency to develop that list on their own, but not that there would be no requirement because it wouldn't be in rule and reg or statute that those businesses be regulated.
Senator Tyson.
Thank you, Madam Chairman. I understand the intent but the problem is this is an issue with all the rules and regs.
Yes.
It's not just with wildlife and parks. So this does not solve the problem. I don't think we create the list. I don't think we ask the agency to create the list. I think we resolve the problem in the process itself. Thank you, Madam Chairman. Thank you, Madam Chairman. The last thing we need is another government list and another government database. There needs to be a simple way for businesses and others to see when these, just popping up within 15 days. There's not going to be people that check the website. I mean, it's going to be a burden. We need to have a better process defined. I know the intent of the legislation that passed was to improve the process. It doesn't mean that we don't have a few more changes that need to be made.
Okay, fair enough. Senator Warren.
Thank you, Madam Chair. Isn't part of the process that the department or agency posts public notice of a proposed change or a proposed new rule or regulation and have an opportunity for public comment? And it's then on the business entity or the resident of Kansas to look for it. If you have an interest, you go out and look for it so that you're not automatically on a list. So I think that is part of our process already, might need to be tweaked. The point of my questions for the Department of Wildlife and Parks was in answering what is the agency's analysis of the enhancement or restriction of business on as a result of the proposed rule or reg is what did the agency do to research? You can Google, who are outfitters for hunting in Kansas? Where are the hunting lodges? That I would think the onus would be on the agency as part of answering that analysis question. They go out and find those. So that may be wishful thinking, but they are likely known to the agency just because they're public. Their business is open to the public generally, and that it wouldn't require a list. But the agency, we heard a different department, they emailed folks that they knew of and are in contact with. So it was disappointing that the Department of Wildlife and Parks didn't do any of that, when surely they know who the industry is that they primarily serve and would want them as the requirement to provide agency analysis for these proposed rules and regs. What have you done to talk to stakeholders? And don't necessarily put the onus on the stakeholders, but on the department and the agency. And in that case, it looked like Department of Wildlife and Parks didn't do any of that. They said they didn't do any of that. So just a comment that the onus is on the agency putting forth the proposed rule or reg to go out and contact stakeholders.
Well, and my other comment was
at least some of them
can talk to the Department of Tourism because they know where everyone is. And they could probably just email or send out a notice on their website. Contact us if you know how this there's some regulations coming out. Please contact us. How much money do you make in a year? And if they limit the number of licenses to out-of-state people, they would already know. This is how much we got from out-of-state hunters. These people, they're always estimating things. So we're not asking for hard and fast numbers. We're asking for estimates. So I just think there's more that can be done for Department of Wildlife and Parks. So Jordan, you got all that?
Thank you, Madam Chair. So I guess I would just ask for clarification about what the recommendation would be then, since it seems there's been some different discussion points. So would something more along the lines of the committee would urge the agency to specifically contact stakeholders that may be affected by rules and regulations changes in the future. Um, I don't know if there's something like that, or if it should be more specific than that.
Perhaps talk to Tourism Bureau for ideas of how much money is involved in this. Yes, Senator Francisco.
Thank you, Madam Chair. So I'm remembering this focus to be the change in fees, right? So the only regulation was really, here are the fees that we're going to increase. And the testimony from the agency was, we think we're going to issue the same number of licenses. So what would you go and talk to a hunting lodge about if you said, last year we had, I don't know, I'm just going to say it, 250 out of state double deer permits. We're thinking we will probably still have 250 double deer permits. How is this going to affect you? I mean, so I think that Senator Tyson's idea is that we really try to track, is their logic about increasing the fees, has that borne out? But other than that, I don't know what you'd get stakeholders to comment on, because they're saying this, it's going to be the same number of licenses. And so do we think if they had to spend 190 instead of 150 on a license, that they're going to look for a cheaper place to stay?
Well, I can tell you that any tourism department, whether it's the chamber or the in Hayes or anywhere, they can sit down and figure out right away, we get this many dollars in from out of state. And that they just call hotels and they get numbers. So I don't think it's something that they have to spend a lot of time doing. But they don't feel like I mean, prior to this, they had nothing. There was no economic impact. And all of a sudden it comes up at $3.7 million. That's a huge impact. So if you're adding $3.7 million onto your fee fund, I'd like to know how. I mean, are you asking more fees and then we're not getting people in? Maybe the tourism people would know. They do it all the time. But anyway, I think we're beating a dead horse. Does anyone else want to?
Madam Chair.
Where's horse beating? Yes.
Hayes Rep. Penn. I just had a quick question. I don't know if it registered while we were having the discussion, but there is a cost associated with all of the regulations being revoked and everything. And if they went through their books and saw how much they were actually saving, could those funds that are freed up be reallocated against their $3.7 million ask that they're saying that they need to have? I was just kind of curious of that. If you could ask the agency to break that down for us, see where the cost savings are, see if they have the latitude to reallocate those funds.
I'll tell you what. Did we have any other questions for other agencies that we could get taken care of and then come back and we can work it out?
Madam Chair, I do have a specific comment that you had made about thanking the KDHE for emailing the stakeholders with regard to the spill rules and regulations. I didn't know if that was something you wanted recorded as an official recommendation. Well, comment, I guess, within
yes,
that.
please. And then we have Secretary of State. Do we have much?
Thank you, Madam Chair. I did not note any specific comments for the Secretary of State. There was quite a bit of discussion, but I didn't have any specific points unless someone has one they'd like to remind me of.
Senator Warren.
Thank you, Madam Chair. Just maybe on 74314, the official stamp, when in subsection A, it says any notary public shall affix an official stamp. maybe change it to the notary public shall affix an official stamp. Thank you.
Thank you, Madam Chair. Appreciate the reminder on that statement. I had it in my notes. I just had not highlighted it. So thank you.
Yes, Senator McGinn.
Back to the spill, can we put in there that they need to at least respond back within 3 days or something like that?
Yeah, you decide. If you have to report it within 24 hours, I don't think it's unreasonable to expect them to report back to you in 24 hours. If you have to do it that quickly, they have to at least get back to you and say, we see it's a major problem, or it's not a big problem. They should be able to get that. So that's up to you. That was your question.
Well, I would give them more than 24 hours just because they may have to do research on their end. Okay. And so I'd say within three, well, they said they'll work anytime, within 3 days.
I think that's fair. Representative Carmichael.
Thank you. I think I'm tracking with you, Senator. But we're talking about the person who's the complainant, the person who reports the spill. We're wanting the agency to affirmatively get back in touch with them within a given period of time to let them know at least the initial disposition of the complaint. Okay. I just kind of want to make sure we're on the same track. That's our suggestion. We could literally go put it in the law, I suppose, but at this point, we're just recommending that they give consideration to doing that. Or we would encourage them, or however you want to phrase it.
Encourage them. Great. Or is that too much? All right. Do you need anything else, Jordan? Do we want to hash any? Senator Tyson.
Thank you, Madam Chairman. I know that's it for today, but I want to bring up when we had the hearing and we recommended the rules and regs not go through for the train. They ignored it. I don't know if you saw the response to us. Respectfully. So I don't know if this committee or how we should address that, but I think there should be legislation to address that issue next year. So would that be a committee bill, or?
We most certainly could make it a committee bill.
Okay. Thank you, Madam Chair.
Yeah, I agree. Representative Carmichael.
Thank you.
I'm sorry.
My question number one is, are we in fact making a recommendation for a bill? And if we are we going to see a draft that we're going to consider introducing as a committee bill? Or how's this working? Because I'm not at all sure that I agree with all of the committee members, and we may need to hold a vote on whether we do or do not introduce a committee bill. But I don't want us to just send one in without it ever coming back for us to.
Well, I think it's reasonable to expect it coming back to the committee before anything goes.
Then I can save my venom for another day.
There you go.
Chairman,
all right.
If I may, the representative has been on the committee long enough to know that we do not put it out of here without seeing the actual.
Well, I would presume that to be the case.
I will make my request formal in the sense that we draft legislation to address the decline of the Department of Transportation ignoring the request of the committee. Because we did vote on that request. That request was voted on. A majority of the committee members requested, and it was declined by the Department of Transportation. And the fact that there was a Attorney General's opinion from one that was completely opposite of another, I mean, it just, to me, it was convoluted.
So are we talking about the railroad regulation? Is that what this is? Okay, yes. I don't know. I mean, just in the context, I wasn't sure which circumstance we were talking about.
Senator Warren.
I appreciate the clarification as well. And it wasn't about training for the railroad employees. It was how many employees.
2 engineers.
And was engineer the correct word, or was it 2 employees on the engine? what was the word?
Conductors? No.
Crew, a two-man crew required. And so I'm a little bit confused about what the request for the bill is still.
The short
That-
line railroad said that instead
Oh, I
of
know what
having
the
two in
controversy
there,
was, but
right,
what's the bill we're requesting? And are we going to vote on it?
maybe me. And then yes, I think we're
So we're not
I think we're splitting
affirmed
hairs.
that we're going to make any suggestions. So just trying to be
Yes,
clear about
yes,
it.
please. Thank you. I guess you're new to the committee, but the committee
Well,
has
now, wait a minute. This is my at least third year on the committee. So no, I don't have the longevity that you do.
never gone forward with language of a bill proposal without the committee reviewing the language. I'm just making the request for the authoring of the bill.
That's good clarification.
There you go. Perfect. That's perfect. That's perfect. Yes, Jordan, have we messed you up completely?
Thank you, Madam Chair. I've got about 4 or 5 notepad sheets here just to make sure that I've got it all down. But I did want to circle back to wildlife and parks, if that's okay, just to be absolutely clear what the recommendation is, because just in the discussion, I've heard some points made about whether they should be contacting these folks that may have an interest in these rules and regulations, or whether there should be some sort of list. Would something more along the lines of the committee urges the Department of Wildlife and Parks to specifically contact businesses that may be affected by these rules and regulations and include any relevant feedback in their economic impact statement, something along those lines. That was a little bit.
That's good to me.
Okay, we will make that text part of the recommendations of the committee then.
Anything else? Because we're slowly but surely losing our members online and here. So, oh, that's right. That's right. Okay. Well, I want to thank everyone for being here. I thank staff for their help. What did we decide on the next meeting? Or Jill Shelley has to come back up and do this.
Thank you, Madam Chair. Jill Shelley, Legislative Research. The next rule and regulation coming before you has its hearing on December 13th. I would suggest the committee consider its next meeting for the last week in November or the first week in December.
For me, I think the first week of December would be better. But I could do it the week before, I guess. I'm looking at it because it's after Thanksgiving.
There is an interim committee all day on December 6th.
All right. How about on the 27th of November? The Monday. It's after Thanksgiving.
There is a 911 Next Generation. Oh, no, that's October. I'm off on the month.
Well, let's try either the 27th or the 28th. I guess I'm hearing mostly the 27th. So not too hard because it's too close. Yeah, it's too close to Thanksgiving. We get someone to fill in. We'll find somebody. All right, let's just tentatively plan on November 27th, and this meeting is adjourned. Thank you all for being here.